You are listening to Based in Fact, a true crime podcast. Join hosts Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 4 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 1, State of Florida versus James Milton Dailey, Part 2. Guest co-host Rick Mullinax joins us to wrap up our look at the case against James Milton Dailey, who was convicted and sentenced to death for the May 5th, 1985 murder of teenager Shelley Elizabeth Boggio. We'll pick up where we left off in Part 1 with a look at Dailey's renewed federal habeas efforts and 4 motions to vacate his conviction and sentence that he pursued in state court. Rick founded Burn After Reading, the YouTube channel that started with a deep dive into the West Memphis 3 case and has expanded to shine a light on the shadier aspects of social media coverage of true crime, including the disappearance of Maura Murray and the murders of Livy German and Abby Williams by Richard Allen in Delphi, Indiana. And welcome back, guys. Great to have you.
Yeah, welcome. Happy New Year, everyone.
Happy New Year.
Happy New Year. Thank you for having me again.
Oh, thank you for making time for us, Rick. And I want to say, the elephant in the room on January 1st, 2025 at 3:15 a.m., a lone terrorist did drive a vehicle down Bourbon Street. He killed several people with the vehicle. He opened fire and was subsequently killed by police. We are still working to recover from that event. It was surreal and remains surreal. And it just gives you a new perspective on life, I think.
Yeah, well, I'm glad you're safe. Yeah, it was such a tragedy. It's a terrible way to start the new year with 2 terrorist attacks, one in New Orleans, one in Las Vegas. As I said, I hope 2025 is getting it out of its system earlier, so it's not another insane year.
Yeah. Thankfully, the Las Vegas attack didn't do as much damage as he intended.
Yeah,
probably because he chose the wrong vehicle.
Yeah.
Which that's probably about the only thing those cyber trucks are good for. Have you seen them in real life?
I have. I just laugh. I think the coal-powered cars are kind of silly anyway. But yeah, the cyber trucks are just so ugly.
I mean, it's like there's a meme going on around on Facebook to the tune of that Wellerman song.
It reminds me of an old like G.I. Joe or Transformer action figure. That's
Yeah, exactly.
and for some comments there have been some comments on Apple, which I don't have, so I really don't pay it that much attention to. But I just want to say, true crime can be a very difficult topic to cover. And so if there are moments of levity beginning or during, we don't intend to insult anybody. We just have to stop being so serious sometimes.
Absolutely. And, again, my condolences to, the people, in Louisiana and in Nevada and Las Vegas. That's a terrible thing that happened. That was in New Orleans, correct? In Louisiana? Or am I getting the city?
Yeah. This show. Oh, sorry. I didn't mean to interrupt.
No. I was just saying, that was New Orleans, Louisiana, or was that a different city in Louisiana?
No, it was New Orleans. It was Bourbon Street. It was from Canal. He ran through Canal through to the 300 block. And then there was apparently a light or an observation, not a crane. It was one of those basket things parked in the middle of the street.
Wow.
And he collided with it.
Yeah,
And that's the only thing that stopped him.
That was right in front of the Royal Sonesta, right? Right in front of the.
I believe so.
Yeah, is it the Desire, the bar that's right there? I've been there so many times, but yeah, right down the bottom of the Royal Sonesta.
Yeah, I haven't been down there in so long. The last time I was down there was for, our Christmas party is on the riverfront. But the last time I was in the quarter proper was for a Christmas party, I think in like 2017.
Oh my gosh.
Yeah.
Well, I guess I was dreaming. I thought your office was on Canal. I guess I completely dreamed that.
You dreamed that. My office is on Poydras.
Okay.
Which is the main street adjacent to Canal.
Right.
It's like Poydras, and then you go down to Canal, and then when you go across Canal, you're in the quarter.
Yeah, so you're more downtown than
I'm in more downtown. I'm across from the Superdome.
Oh, nice.
Mm-hmm. Yeah. So
speaking of, did you go to the game and watch Notre Dame put a whipping on Georgia?
No, I did not. I do work across the street, and I did have to deal with trying to leave at noon, and they closed Poydras completely. They closed a lot of streets leading to Poydras completely, and it took me about an hour and a half to get home, on what should take about 20 minutes.
Oh.
So,
well, my last New Orleans comment will be for everyone listening. If you haven't read it, one of the best books ever written was Confederacy of Dunces, which
yes,
such a great book. And it begins with the old department store right there on Canal. I know it's been closed for a while, but
I think that was D.H. Holmes.
Yeah, I think that's right. And then I've seen many of the he pushes the hot dog cart. I've seen many
Lucky
of those.
Dogs. Yep.
But Confederacy of Dunces, if you haven't read it, it's a great book.
It is. I would highly recommend it. The author had such a tragic life, though, and it mirrored in the character's life, whose name right now completely escapes me, as does the author's name, which is horrible. But I read it in 1986, so I have a little bit of an excuse not to be able to remember that far back. But it's one of my
John Kennedy Toole was the
John Kennedy. That's
author
right.
Who, and actually, the last thing I'll say, but actually one of my favorite authors, like maybe my favorite author besides Flannery O'Connor, is another New Orleans guy, Walker Percy. So all of you out there, read some Flannery O'Connor and Walker Percy.
Okay.
In addition to Confederacy of Dunces.
And we can't forget the late great Anne Rice.
Yes, of course.
And her son Christopher, who's a very talented writer.
I've never read his stuff. I've only read Anne's, but I do like the new AMC series that they got. I didn't know if I would like it, but surprisingly, I'm enjoying it.
I've liked both Interview and Mayfair.
Mm-hmm.
I'm looking forward to the next seasons of each of those.
Agreed.
All righty, so now we're back off with the show. Of course, our victim was Shelley Elizabeth Boggio. She was born July 9th, 1970 in Battle Creek, Calhoun County, Michigan. Her parents were Frank Leonard Boggio, who died in 1992, and Cheryl Darlene Eddie Gustafson, who died in 2003. She had 5 sisters: Sherry Renee, who died in 2018, Stacy Marie, who was her twin, who died in 2003, Myra, Brittany, and Callie. She was a student at 16th Street Middle School, but she dropped out in the 7th grade after the families moved to Florida in 1984. And her cause of death were multiple stab wounds, 31 with 18 defensive wounds, and asphyxiation by manual strangulation and drowning. The perpetrators in this case, the perpetrator is James Milton Dailey, June 11th, 1946, Spokane, Washington. He's an alcoholic and a drug addict. He's manipulative. He probably has a temper issue as well. He has prior crimes of fighting, assault, DUI, and aggravated battery, for which he has a conviction in Pima County, Arizona in 1979. His victim was Shelley Elizabeth Boggio, age 14. Then his accomplice, Jack Edward Piercy Jr., born May 13, 1955 in Maryland. He's also an alcoholic, drug addict, con artist, and manipulative. He has prior crimes of theft, conspiracy to commit murder, drug dealing, and possession. And I believe there are some assaults in there as well. And his victim is Shelley Elizabeth Boggio. The crime occurred on May 6, 1985. The victim, Shelley Boggio, age 14. It occurred on State Route 688 in Indian Rocks Beach, Florida, which is in Pinellas County. Again, warning, I will mispronounce that name frequently during this program. On May 5th, Shelley spent the day with her sisters and friend Stephanie. That afternoon, she encountered Dailey and Piercy, who picked her up while she was hitchhiking with her twin and Stephanie. Shelley knew Dailey and Piercy and had hung out with them before. After spending the afternoon and early evening drinking and smoking pot, the group went back to Piercy's rented house in Seminole to continue partying and watching TV. At around 10 p.m., the group left the house. After dropping Stacy and Stephanie off at an apartment complex, Dailey, Piercy, Shelley, and Piercy's girlfriend, Gail Bailey, headed to Jerry's Rock Disco, where Shelley used Gail's ID to get into the club. While there, Shelley rebuffed Dailey's advances, choosing to dance with Piercy. At around midnight, they left Jerry's to return to the house. Piercy offered to bring Shelley home, and Shaw asked for a ride to a nearby payphone to call his girlfriend in Kansas. Dailey claims he went to his room and went to sleep, but Gail testified that when she returned from the bathroom after their arrival at the house, Piercy, Shelley, and Dailey were gone, and this upset her. Piercy has claimed that he returned to the house and picked Dailey up after dropping Shaw off at the phone. Between 2 a.m. and 3 a.m., Piercy and Dailey returned to the house. Dailey was carrying his shirt, wasn't wearing shoes, and his pants were soaked to the top of his thighs. Some witnesses described them as wet to the waist. Based on the autopsy findings, it's clear that Dailey tortured Shelley, stabbing her 31 times. Shelley sustained 18 defense wounds to her hands and arms during the attack. When the stab wounds didn't kill her, Dailey threw Shelley into the water, choking her and then holding her head under until she stopped struggling. He and Piercy then returned to the house like nothing had happened. Shelley's body was found the next morning by a bridge tender. At the house in Seminole, Gail removed Shelley's belongings when she found them in the car. After a quick trip to a laundromat where Piercy and Dailey were observed engaging in hushed conversation, the group headed to Miami. The next day, Dailey boarded a bus for Tucson, Arizona. Eventually, he made his way to Monterey, California. Piercy returned to Olathe, Kansas, where he was arrested on May 21, 1985. During a series of statements, he named Dailey as Shelley's killer. Piercy claimed to have been asleep or passed out in the car and that he woke to the sound of Dailey murdering Shelley. Piercy was extradited from Kansas to Florida on July 17, 1985. Dailey was eventually located in California in November 1985 and extradited to Florida on February 12, 1986. Piercy and Dailey were held in the Pinellas County Jail awaiting trial. During their stay, they enlisted other inmates as go-betweens, using them to pass notes back and forth. Dailey made numerous incriminating statements to those inmates who came forward and testified against him at trial. Some of their testimony about Dailey's statements was corroborated by the handwritten notes exchanged by Dailey and Piercy. And so, first of all, we're going to kind of recap the case against Piercy. He was convicted on November 22nd, 1986, and sentenced to life without parole on November 25th. His judgment and sentence were entered on January 8th, 1987. His direct appeal, his conviction and sentence were affirmed. His initial state post-conviction motion was denied on December 11th, 1989. He did get a motion for rehearing, and then the court reconsidered and issued an order denying the post-conviction relief on March 28th, 1990. the Florida Supreme Court, or it's the Court of Appeals, 2nd District, I think, affirmed on August 3rd, 1990. The mandate for that issued on September 24th, 1990. He never filed any writs to the U.S. Supreme Court, or at least none that I could find. And then he filed a petition for state post-conviction writ of habeas corpus in the 2nd District Court of Appeal. That was denied on December 5th, 1991. And so once all that was finished, and he's never filed federal habeas either, he gave a sworn statement to Dailey's attorneys, which basically he attempted to exonerate Dailey. And that was on March 19th, 1993. Then on January 28th, 1998 and March 5th, 1998, Piercy sent 2 letters to Stacy Boggio, Shelley's twin sister. In the first one, he admits that he was present when Shelley was murdered. He claims he was so high and drunk that he didn't realize what was going on until it was too late. He wishes that he says he wished he'd killed Dailey then, and he wouldn't be upset sitting in prison if he had. And he apologizes to Stacy for not stopping Dailey from killing Shelley. The second letter, he tells Stacy that she should not feel guilty for not staying with Shelley that night. And basically says this was fate or destiny, and there was nothing anybody could have done to stop it.
I mean, other than their actions.
Yeah, other than their actions. But
do you feel he's gaslighting Stacy? Like, that's a very weird letter.
I think he's a con artist. He's probably gaslighting Stacy to a degree. He was engaged. He was communicating with Stacy at this time. But it also may be he's a con artist, and he doesn't want his family to think less of him.
I see.
So he wants his family to think that he's a good guy.
So it's a perception thing.
Right. And
okay.
I mean, his parents and his mother and his siblings all seem like they're really stand-up people. But he's not.
Right.
And that's why I say he's a con artist. So some of it
but
may
he had a pretty normal.
Yeah, he did.
I mean, he didn't have like a messed up childhood, right? He was relatively normal, right?
Not that but he was like the rebel without a clue. Just doing bad for the sake of bad. Because he does have a pretty extensive minor criminal history in Kansas. And, he was involved in a murder for hire scheme. He didn't follow through, but he was willing to entertain the idea. Dailey's attorneys make him look like, the master criminal, but he really, the number of times he got caught, he ain't no master criminal. So then in April 30th, 2004, Piercy's request for DNA testing on some of the evidence used against him was denied. Now, interestingly enough, Dailey has never sought DNA testing. Which some of that evidence corroborated, evidence against him, corroborated statements against him. So maybe it might have been a good idea. Then that was affirmed by the District Court of Appeal on December 29, 2004. Then in 2017, he started giving exculpatory statements on behalf of Dailey to Dailey's attorneys. He gave an affidavit on April 20th, 2017, which basically says Dailey was not present when Shelley was killed and Piercy is responsible for her death. But then there was a hearing and Piercy refused to testify, which we'll go into a little bit more later. And then during a prison visit with Josh Dubin, he signed a declaration, which again said Dailey had nothing to do with Shelley's murder that Piercy committed the murder and that Dailey was at home at the house in Seminole when he drove Shelley to the place where he killed her. He also gave a deposition on February 25th, 2020, although that was not quite as exculpatory because most of the deposition was just Dubin having him say, yes, I gave this statement. Yes, I said this. Yes, I said that. And then there was a hearing on May 5th, 2020. And again, Piercy refused to testify on behalf of Dailey, and we'll go into that a little bit more as well. Then we have the case against James Milton Dailey, and I just want to start off by saying, independent of Jack Piercy and his initial statement, which is why Dailey was arrested in the first place, cops didn't even know who Dailey was at the time Shelley's body was found. These witnesses were the jailhouse witnesses, and basically James Leitner, he relayed messages between Piercy and Dailey during December of 1986. He informed Dailey what happened at Piercy's trial. Dailey asked him to tell Piercy that if Piercy got a new trial on appeal, that Dailey would then testify and tell what really happened, i.e. that Dailey was the one that killed Shelley. Leitner told Dailey that it was important that Dailey not testify at his own trial because he would be charged with perjury if he testified differently at a retrial for Piercy. When another inmate asked Dailey why he killed the girl rather than just knock her out since she was only 14, Dailey responded, "Man, I just lost it." Pablo de Jesus is the second inmate. He met Dailey in December of 1986 when he gave Dailey a note from Piercy. Dailey asked Jesus to tell Piercy not to worry, that Dailey was the only one that knew what happened, and as long as Piercy didn't break down, Dailey could beat the case and then help Piercy. Dailey said that he and Piercy were fall partners. He informed Piercy that Dailey said not to worry, that he would not take the stand and could beat the case. Dailey asked Jesus to reassure Piercy that Dailey would beat the case, and Dailey then would tell the truth, i.e. that he killed the girl. In response to Jesus' question about killing Shelley, Dailey's response was, "Man, I just lost it." And then there's Paul Skalnick in April of 1997 or May of 1997. Dailey asked Skalnick if he knew whether notes between friends were admissible in court. Dailey told Skalnick he had given notes to the law librarian to be passed to his friend. Dailey told Skalnick that Piercy had done more than he had said, that he had stabbed the girl too. Dailey told Skalnick that Piercy actually held the girl under. Dailey told Skalnick that the girl kept staring at him, screaming, and would not die, and he stabbed her and he threw the knife away. And then the evidence against Dailey at his trial was the notes, which were in Dailey and Piercy's handwriting, that Leitner copied, and DeJesus may have copied as well, that were used at Dailey's trial. So something we don't see in the advocacy work are those notes. They're probably part of a state response that I did not find. But the Dailey's attorneys aren't even honest about the existence of the notes. So he was found guilty of murder in the first degree on June 27, 1987. He was sentenced to death on June 30th, 1987 by a vote of his jury 12-0. The judgment and sentence were entered on August 7th, 1987, and he was given death, which he had asked for. And I believe that was in a letter to the court, which I don't remember whether I found that for you, Rick, or not.
I don't know if you gave me the letter, but I do know that was one of the things that I found interesting, was the fact that he was asking for the death penalty.
Right. So, but now that he's got it, he doesn't want it.
Right.
So then he filed a notice of appeal. The appeals court decision came down on November 14, 1991. So that's about a 4-year period on direct appeal. Just, so we're not having an appeals court that's just immediately rubber stamping a verdict and sentence. In the direct appeal, the court affirmed the conviction but reversed the sentence and remanded, finding that the lower court erred in finding as an aggravating circumstance that the murder was committed to prevent a lawful arrest. The evidence also failed to support the finding that the murder was committed in a cold, calculated, and premeditated manner. Then the case went back for resentencing, which an order was entered on January 21st, 1994. And that sentenced Dailey to death. Then Dailey had another round of appeals on the sentence. That decision was rendered on May 25th, 1995. The court affirmed appellant's death sentence. The court held that appellant's failure to raise at trial the issue regarding alleged vagueness in the jury instructions on aggravating circumstances barred him from raising the claim on appeal, that the record supported a finding of no mitigating circumstances, and that the trial judge was not required to disqualify himself when the case was remanded for resentencing. On August 22nd, 1995, rehearing was denied, and the decision was released for publication. He filed a writ of habeas corpus, a writ of certiorari to the U.S. Supreme Court on November 20th, 95, and that was denied on January 22nd, 1996. So his conviction and sentence became final on January 22nd, 1996, 11 years, or just shy of 11 years after he murdered Shelley Boggio. Then Dailey began the process, long and drawn out, of state post-conviction. Well, long, but not drawn out yet. The court entered an order denying his motion to vacate judgments of conviction and sentence on July 14, 2005. It was an 82-page decision. And the state post-conviction process began, I think, in 2000 or thereabouts. So again, this isn't a rubber stamping. There were hearings held, etc. His motion for post-conviction relief was denied, and he had 30 days to appeal. He filed an original petition for writ of habeas corpus with the Florida Supreme Court on March 21st, 2006. And oral argument was held on February 13th, 2007, and the decision was rendered on May 31st, 2007. The High Court affirmed the trial court's denial of the inmate's post-conviction claims and denied his petition for a writ of habeas corpus. And then they denied rehearing on September 10th, 2007. Then he moved on to federal habeas in federal court on September 29, 2008. The respondent's motion to dismiss was granted on some grounds and dismissed and those claims were dismissed as procedurally barred. Ground 5 was dismissed for failure to allege a federal constitutional claim, and then Dailey was given 45 days to file a response addressing the merits of his remaining claims. And then on April 1st, 2011, his petition for writ of habeas corpus was denied. The clerk was directed to enter judgment against the petitioner and close the case, and a certificate of appealability and leave to appeal in form of pauperis were also denied. That judgment was entered. Judgment was vacated to allow amendment to add the claim of ineffective assistance of counsel and to correct an error in one of the documents misidentifying Piercy. His claims of ineffective assistance of counsel for failing to object to prosecutor's argument did not warrant relief and was therefore denied, and the order was amended to reflect the denial of that claim. He also was ordered that he wasn't entitled to a certificate of appealability or form of pauperis, which means he'd just have to pay in the appellate court all of his expenses or get leave to proceed in form of pauperis with them. The judgment was entered on March 30th, 2012. He appealed to the 11th Circuit Court of Appeal. His COA and IFP status were denied initially, and then on July 19, 2012, IFP status was granted, but the COA was denied. He filed a motion to reconsider, which was denied on September 24, 2012. He filed a request for extension of time with the U.S. Supreme Court, which was granted on December 18th, 2012. He filed his writ of certiorari on February 21st, 2013. And on April 29th, 2013, his petition was denied. Then he had his clemency proceedings. He had an interview on September 10th, 2015, and he filed a brief in support on October 24th, 2015. And that's the end of clemency proceedings under Florida law. So then he returns to state court. He filed a successive motion to vacate on April 13th, 2017. That was, or rather on April 13th, that was denied. He tried to get it reheard, and that was denied on May 12th, 2017. Then he appealed to the Florida Supreme Court. And while that was pending, he filed a successive motion. So the Supreme Court relinquished jurisdiction. That process was over on April 11, 2018, when the court entered its new order. Oh gosh, guys, I'm sorry. Somebody just rang my doorbell.
Okay.
Is it your Walmart grocery order?
I have no idea. I have no idea. But somebody just rang the doorbell.
Oh, Lisa, I think we lost you.
I think
Still
we did.
here.
Oh, okay.
Yeah, I'm still here. Would one of you guys mind taking over?
Yeah, I could start. I can read it out, and when you come back, you can take over.
Yeah, let me run and see what that's about.
Okay, so I'm not Lisa O'Brien, but I'm going to give this the old college try. So here we go. So on April 11th, 2018, there's an order and the relinquishment ended. And then on April 12th, 2018, order to show cause. Appellant shall show cause on or before May 3rd, 2018, why the trial court's order should not be affirmed in light of this court's decision in Hitchcock versus State. Response is limited to 20 pages. Appellee may file a reply on or before May 18th, 2018, limited to no more than 15 pages. Appellant may file a reply limited to no more than 10 pages on or before May 29th, 2018. And then May 2nd, 2018, response to show cause, that was by Dailey. And then on May 13th, 2018, reply to order to show cause by the state. Reply to reply on May 28th, 2018 by Dailey. And the opinion on June 26, 2018. So after reviewing Dailey's response to the order to show cause, as well as the state's argument in reply, we conclude that Dailey is not entitled to relief. Dailey was sentenced to death following a
Sorry
jury's...
about that.
Oh, I was just on June 26, 2018, if you want to take over.
All right, perfect. So this is the opinion, and this is on just the initial motion to vacate. Again, for the recap, I kind of tried to pare it down a little bit. Not as much as I thought, but so on June 26, 2018, the Florida Supreme Court entered its opinion, and they said after reviewing Dailey's response to the order to show cause, as well as the state's arguments in reply, we conclude that Dailey is not entitled to relief. Dailey was sentenced to death following a jury's unanimous recommendation for death. On appeal, this court reversed Dailey's death sentence and remanded for resentencing before the trial judge. On remand, the trial court again sentenced Dailey to death, and Dailey's sentence of death became final in 1996. Thus, Hearst does not apply retroactively to Dailey's sentence of death. And that's, that was his initial state post-conviction, was challenging the resentencing. Mandate issued. His petition for certiorari to the U.S. Supreme Court was denied on January 22nd, 2019. And then he had a second successive motion to vacate, which was based on Piercy's 2017 quote affidavit. And there was a hearing held on January 3rd, 2018. And while Piercy agreed that he signed the affidavit in the case, he testified that the statements were not true. Piercy explained that the part of the affidavit listing his name and the fact that he was sentenced to life in prison were true, but Piercy refused to answer any questions about the truth of the remainder of the lines in the affidavit. So Piercy signs an affidavit that says Dailey's not guilty, but then when it comes time to testify, he's like, oh, no, that's not true.
Playing games.
Yeah, I think it is. I think it's a little bit of an extension of the games that they were trying to play prior to their trials.
Mm-hmm.
So, and for the most part, because of the refusal of Piercy to testify consistent with the affidavit on March 20th, 2018, the second successive motion to vacate was also denied. Or was denied in part and dismissed in part. And that was appealed to the Florida Supreme Court, and they issued a decision later. His death warrant was signed on September 25th, 2019 by Governor DeSantis and set his execution for Thursday, November 7th, 2019 at 6 p.m. And that's where we got last time. That's where we stopped. So now, this is where my apologies, people, because we're going to be jumping back and forth in time and back and forth from one court to another, because there were just a flurry of efforts on Dailey's part, or on the part of his attorneys, to try and challenge his conviction and sentence. So they were not successful, but you cannot say that they did not make the effort. So he filed a successive federal habeas claim in United States District Court for the Middle District of Florida. He was represented by Carol Wright, Rahila Ahmed, and Tenny Martin. He filed an emergency motion to appoint counsel, and the state filed a response. He filed a motion for leave to file a reply, and I believe that was granted. The motion to appoint was granted on October 1st, 2019, and the motion for leave to reply was denied as moot, and the motion of one of the state draw was quash, which was opposed. The motion to quash was denied, so there was some discovery conducted in this proceeding. He filed an emergency motion for stay of execution on October 18th, 2019. That was, the court ordered that the state respond to that by October 22nd. They filed their response. Dailey filed a motion to strike their response and an alternative file a reply on the same date. And on the 23rd, the court entered an order. The matter comes to the court on petitioner James Dailey's motion for a limited stay of execution, in which he moves the court to stay his execution schedule for November 7th, 2019 until December 15, 2019. Respondents oppose the motion. The court stays imposition of the death penalty for 90 days from appointment of federal counsel until December 30th, 2019, at which time this stay will automatically dissolve. Now, unfortunately, that means Dailey was not executed on November 7th. And he continued state post-conviction actions. His second motion to vacate was decided on October 3rd, 2019 by the Florida Supreme Court that held that the trial court did not err in denying the inmate's successive motion for post-conviction relief because given that the affiant claimed the affidavit was false and refused to testify about any of its substantive assertions, his affidavit was hearsay of an exceptionally unreliable nature and did not qualify as a statement against interest under Florida law. He had already been convicted of the crime to which he confessed and did not expose himself to any additional criminal liability for the victim's murder by accepting sole responsibility for her death. The post-conviction relief petition was also untimely or otherwise procedurally barred because the information was not newly discovered since it was known to the inmate in 1999, so that judgment was affirmed. He filed a motion for rehearing and clarification, which was denied on October 14, 2019. The mandate issued, and then an order releasing the opinion for publication was entered on October 23rd, 2019. On January 7th, 2020, Stacey pursued another petition for writ of certiorari, number 19-7309. The questions presented: since being convicted of murder and sentenced to death in 1987, petitioner James Dailey has steadfastly maintained his innocence. No eyewitness, physical, or forensic evidence connected him to the crime. The state's case at trial hinged almost entirely on the testimony of jailhouse informants, none of whom surfaced until after a jury had already rejected a death sentence for Dailey's separately tried co-defendant, and the lead detective had combed Dailey's jail pod looking for new potential witnesses. Now, this is, these are facts that these are conclusory allegations by Dailey, not really proven fact. And that's one of the difficulties is that on both sides, a lot of times there's a blurred line between proven fact and actual evidence in these briefs. So they were talking about new evidence that they had uncovered that they hadn't even presented to the courts yet. And their reasons to grant the writ. I'm not even going to go into the questions presented rather than going through and this is also written for basically the media, because the media just runs with these conclusory allegations. So the question presented was the Florida Supreme Court's analysis of Chambers versus Mississippi employing a factor-based approach that has been embraced by some courts but rejected by most others unconstitutional. And their reasons for granting, they claim that under Chambers, the Due Process Clause requires courts to consider exculpatory hearsay even if inadmissible under state evidentiary rules when the evidence is sufficiently reliable and material to the defense. The Florida Supreme Court misapplied Chambers in analyzing the code of evidence hearsay confession under a 4-factor test that disregarded corroborating evidence. The Florida Supreme Court's factor-based approach conflicts with how other state and federal courts apply Chambers. Under a correct reliability analysis that considered corroboration, Jack Piercy's repeated confessions would be admitted and would result in Dailey securing a new trial. Because 1, Piercy's multiple confessions bear strong indicia of reliability under Chambers, and consideration of Piercy's statements will likely result in Dailey obtaining a new trial. Amici briefs were filed on behalf of the United States Conference of Catholic Bishops and Florida Conference of Catholic Bishops, Inc., and former or current prosecutors or attorney general and conservatives concerned about the death penalty. The state filed its brief in response, and their statement of the questions presented was whether the Florida Supreme Court erred in applying Chambers versus Mississippi to the facts of this case. Their reasons for denying the decision below does not contravene this court's holding in Chambers. Review is not warranted to resolve a conflict among the lower courts, and under any reading of Chambers, the decision below is correct. Dailey filed a reply. The brief was conferenced, or the petition was conferenced on October 30th, 2020. The amici briefs were granted. Motion for leave to file them was granted on November 2nd, 2020. And the order denying the petition was also entered on that same date of November 2nd, 2020. And Justice Barrett took no part in the consideration or decision of the petition, possibly because she was on one of the lower courts in Florida, probably maybe the 11th Circuit. I'm not sure what her history is. So then Dailey filed another motion to vacate after death warrant signed, which is actually his third state post-conviction challenge. He was being represented at that time by Chelsea R. Shirley, Jalissa R. Fonten, Kara R. Odervanger, Laura Fernandez, and Seth Miller of the Innocence Project of Florida, Inc. This was filed in the state court, 6th Judicial Court in Fort Pinellas County. Same case number, and the judge is, I believe still is, the Honorable Pat Siracusa. On September 27, 2019, Judge Siracusa was assigned. On October 4th, 2019, he denied in part Dailey's public records demand to the state attorney's office and office of the medical examiner. On October 8, 2019, he entered an order denying additional public records demands, and also ordering that he would conduct an in-camera inspection of records. Some of the records requested, and I'm not going to go into the specifics of what was being requested because they were basically conducting fishing expeditions. He entered a second order on October 8, 2019 after his review and denied production of those records to the defense, and his motion denied Dailey's motions for reconsideration. On October 8th is when he filed the actual motion to vacate. And his claims in this one were that Florida's execution of Dailey would be so arbitrary as to violate the 5th, 8th, and 14th Amendments to the United States Constitution, selecting for execution a 73-year-old Vietnam veteran with a powerful pending innocence claim over more than 100 death-eligible defendants, and compelling him to seek a fire drill review by the courts reveals an opaque, arbitrary, and truncated methodology leading to an absurd result that violates the 5th, 8th, and 14th Amendments to the United States Constitution in Florida and corresponding Florida provisions. The execution of an innocent person whose death warrant was signed while the case remained pending before the court and for whom clemency is foreclosed is so arbitrary as to violate the 5th, 8th, and 14th Amendments. He argues that James Dailey is innocent of the offense for which he is sentenced to death because A, the jailhouse informant testimony that formed the basis of the state's case is utterly unworthy of belief. The killer has repeatedly confessed. Oh dear. My light's not working.
Your lamp?
My lamp isn't working.
Oh,
and
goodness.
I need it. Oh no. Pardon me, folks. I'm really sorry.
That's okay. Let's start off with the first basic question. Did you put a light bulb in it?
Yes, I did put a light bulb in it.
Is it plugged in?
The plug wasn't all the way in, so when I shifted the surge protector, the plug came out.
All right. Success.
So, okay. Crisis averted. Thank you. The killer has repeatedly confessed to being solely responsible for the murder. Well, not really, but okay. The totality of the evidence points to Jack Piercy having killed the victim alone. He also argued Governor DeSantis signed Dailey's death warrant while the Florida Supreme Court was considering Dailey's timely and fully briefed appeal containing a newly discovered evidence actual innocence claim, ignoring the fact that they ultimately denied that claim. And then Dailey has no forum beyond the courts to present as compelling evidence of innocence because the avenue of executive clemency is foreclosed. Claim 2, newly discovered testimonial evidence proves that Dailey is actually innocent. The state's withholding of this exculpatory material violated the constitutional requirements for Brady versus Maryland and Giglio versus the United States and its progeny, thus depriving Dailey of his right to due process and a fair trial. And that newly discovered evidence is allegedly new evidence from the state attorney's office and new evidence from the Pinellas jail. And then Dailey has a constitutional right to have his designated legal witness be allowed to access to writing pad and pen during his execution, 2 attorneys present during execution, attorney access to a phone during the execution, and a witness to observe the insertion of the IV line that will be used to administer the lethal drugs. Claim 4, the totality of punishment imposed by the state violates the 8th Amendment and the precepts of Lackey, which says if you're on death row too long, it's not fair, which is a memorandum opinion that has no precedential value whatsoever. That Dailey be allowed leave to amend this motion should new claims, facts, or legal precedent become available. These are the reliefs sought, that he be granted an evidentiary hearing at a reasonable time, and that his conviction and sentence of death be vacated. A motion to stay execution was filed in state court on October 8, 2019. The state responded on October 10th. A hearing was held on October 11th. He filed a motion to interview jurors, which was denied on October 14th. An evidentiary hearing was held on October 14, 2019, as it related to a claim from a former state attorney who basically said cops told him that Piercy tried to have sex with Shelley and couldn't perform. She laughed at him and he killed her. That was the theory of the case, which it may have at one time been a theory of the case, but that's not what was presented at trial, and not what Dailey could have presented at trial. Dailey could have presented the same thing at trial, because he would know that that's what really happened, because Piercy would have told him that. Then there was a final order dismissing in part and denying in part defendant's motion to vacate judgment of conviction and sentence of death. And it was initially entered, and then it was amended on October 16th to correct a typo. And the findings of the court were: ground 1, defendant's actual innocence and clemency claims are untimely and procedurally barred. And ground 1 is without merit under Florida Supreme Court precedent. Ground 2, as to James Slater, claim regarding James Slater is untimely because it could have been discovered more than 1 year ago through the exercise of due diligence. Slater's affidavit is hearsay and is not admissible to support this claim. Slater's testimony does not provide any favorable evidence admissible at trial, because when he testified, Slater said, "I might have even been thinking of the wrong case at the time of the affidavit." And then another witness, Edward Coleman, basically they tried to claim that police came to the jail with newspapers and showed inmates the newspapers and said, "You need to testify against Dailey," after they couldn't get a death sentence for Piercy. So Edward Coleman was one of the inmates who said, yeah, they came there with papers. The court found that defendants' claims regarding Edward Coleman are untimely and procedurally barred. Even if not procedurally barred, defendants' claims regarding Edward Coleman would be denied because his testimony would not change the outcome of the trial. To the extent defendant raises a Giglio claim with regard to Coleman's testimony, it is vague, conclusory, and without merit. David Hauser was a guard who had negative things to say about Jack Piercy. The judge found that defendant is not entitled to relief on this untimely, conclusory claim. Defendant has not set out any timely, facially sufficient claim with regard to this evidence, and the claim is therefore dismissed. As to cumulative analysis, The court found that that was unnecessary, as with defendant's previous motion, given that all of Dailey's newly discovered evidence claims were either correctly rejected as untimely or based on inadmissible evidence. No such analysis is necessary, and that cites Dailey 5. Defendant is therefore not entitled to a cumulative analysis of his claims. On ground 3, they found that the claim is premature because defendant only anticipates that DOC will deny these requests. Defendant is not entitled to relief on this claim. Defendant has not demonstrated any reason why this case is meaningfully different from Lang, which is a Florida case that says Lackey is a memorandum of opinion that has no precedential value about time on death row. And you also have to consider your time on death row is because you keep filing these state motions and federal motions. And when they set an execution date, you file a motion to stay and you pursue these new claims. Of course, that's going to extend your time on death row. So ground 3 was denied. Ground 4, this claim is timely, but defendant is nonetheless not entitled to relief. Given that Florida case law has yet to find any period of time on death row to be cruel and unusual, there was no particular point prior to now at which defendant should have filed this claim. Regardless, as defendant admits, the Florida Supreme Court has repeatedly held that lengthy periods on death row prior to an execution are not cruel and unusual. Lackey, a 24-year-old memorandum of opinion from 2 U.S. Supreme Court justices, concurring in the denial of certiorari, has no precedential value and does not provide any reason for this court to ignore binding precedent, nor is defendant's period of incarceration on death row so long as to distinguish him from previous cases. Based on Florida Supreme Court precedent, this claim is denied. The court also found that it wasn't appropriate to grant a motion to stay at this time. The court has now rejected defendant's claims within the time frame set by the Florida Supreme Court. The court does not anticipate that the Florida Supreme Court or the federal courts will be unable to review these claims under the time constraints required. If this court is incorrect in that assessment, the Florida Supreme Court or the federal courts have the power to issue a stay as well. And defendant's motion for stay was therefore denied. So basically, the motion to vacate was dismissed in part and denied in part. And Dailey was required to file a notice of appeal by October 17th, 2019. He filed an emergency motion for reconsideration, seeking rehearing reconsideration, which of the orders denying his public records demands and motion to interview jurors. On October 16th, the court denied that request. And he filed his notice of appeal, went to the Florida Supreme Court, still represented by the same attorneys, but he was joined by Eric Pinkard and Maria E. Deliberato. He filed his initial brief on the 21st. I'm not going to go into the arguments on that. He filed a motion to stay execution, which referred to some inmate affidavits saying that the police came there with newspapers and told inmates what to say. He had the stay at federal court, so I kind of don't understand why he's even filing a motion to stay in state court. But he did. And then he also filed a petition for writ of habeas corpus on October 21st, 2019, claiming that his conviction violates the 8th and 14th Amendment because there's insufficient evidence to sustain it. His death sentence violates the 8th Amendment because it's not proportionate to that of his co-defendant. Habeas relief is appropriate. So this court can take a holistic view of the abundance of new evidence of actual innocence that has been deemed procedurally barred, along with the numerous acknowledged errors that have taken place during the course of these proceedings, but have been deemed insufficient to grant relief. Ineffectiveness of post-conviction counsel must provide a basis to excuse state procedural bars to evidence of actual innocence, and the principle governing Hurst requires a finding that Dailey's sentence is inappropriate under a contemporary understanding of due process and given extensive evidence of actual innocence. The state filed a motion to dismiss, to which Dailey responded. That was on the 21st and 22nd of October. On November 12th, 2019, the motion to dismiss was denied as moot, and the court issued its opinion, holding that an order dismissing in part and denying in part defendant's third successive motion post-conviction relief was proper, as defendant's actual innocence claim was procedurally barred. He'd already unsuccessfully raised an actual innocence claim in his second successive post-conviction motion. Defendant failed to state a newly discovered evidence claim, as he neglected to explain why he could not have discovered the information to which a former assistant state attorney testified either prior to trial or at some point during the decades that followed on defendant's petition for habeas corpus, because his claims that there was insufficient evidence to sustain his conviction and that his sentence was disproportionate could have been, should have been, or were raised on direct appeal, they were procedurally barred. So the judgment was affirmed, and his habeas petition and motion for stay were denied. Okay, pardon me.
I know it's a mouthful, right?
No, it is. There were some additional holdings, but I'm not going to go into those. And they also they found that Dailey had not presented any reason for us to hold that the circuit court abused its discretion in denying his public records request. He suggests the circuit court erred in denying the request for records from the DOC and the Office of the Medical Examiner related to the lethal injection protocol. His argument lacks merit because we've upheld the constitutionality of the current lethal injection protocol. Such records are unlikely to lead to a colorable claim for relief. They also have rejected related challenges to the constitutionality of Rule 3.852, which Dailey's attorneys were trying to use for a fishing expedition. The disputed limitations in Rule 3.852H3 and Rule 3.852I are aimed at preventing capital post-conviction defendants from engaging in an 11th hour attempt to delay the execution rather than a focused investigation into some legitimate inquiry. Therefore, these restrictions are reasonable in the context of capital post-conviction claims. And they also found that they've rejected similar claims about length of time on death row, and his arguments do not justify departure from our president. Accordingly, we affirm the circuit court's summary denial of this claim. The mandate was issued. He requested an extension of time on January 21st, 2020 from the United States Supreme Court. The Florida Supreme Court entered an order on the notice of delay because the conclusion of this proceeding was not within the timeline. So they found that the time had expired before Dailey filed these claims. It says Article 1, Section 16B, 10B of the Florida Constitution provides that all state-level appeals and collateral attacks on any judgment must be complete within 2 years of the date of appeal in non-capital cases and 5 years from the date of appeal in capital cases, unless a court enters an order with specific findings as to why the court was unable to comply and the circumstances causing the delay, pursuant to the administrative procedures and definitions set forth in Supreme Court of Florida Administrative Order AOSC 19-76. This case was not completed within the time frame required by Article 1, Section 16B, 10B, because the time frame had already expired by the time this case was filed. So not only is Dailey filing multiple state court claims, but he's filing them long after the time has expired to do so.
Do you think part of this is that they sit in jail for a long time, and then once the execution date gets close, They suddenly are like, oh shoot, we gotta start
Yes.
doing something.
Yes. Well, in Dailey's case, he was pursuing some claims prior to the execution date, but once the execution date was set, he started filing additional claims.
And those are basically they're just throwing Hail Marys at this point. Would that be
Yeah,
accurate?
it's a shotgun. Well, yeah, it's the shotgun approach.
Mm.
And something I found, and the same as with Rodney Reed, like we've had how long with Rodney Reed where they haven't pursued anything? I mean, they've got these few pending things, but they haven't filed a motion in state court with new evidence or anything like that. But as soon as his Fifth Circuit claim on the DNA appeal is decided, and if it's decided against him, they're going to file another new evidence claim with new evidence of witnesses for the affair with Stacy and Fennell killing her and new confessions from Fennell and all those things. Mark my words. So I think Dailey, the same thing's going to happen the next time Dailey's more likely to die of old age in prison.
Yeah, based on like a lot of these cases where the death penalty is put in place, it takes a very long time, and it's very difficult to execute a convicted murderer who has, like I said, has the death penalty. I mean, I don't know if that's a good thing. If that's a bad thing, I guess it depends on the person. But what do you think on that?
I think it should not take this long. Yes,
I agree. And do you think some of these cases too take much longer, and takes a lot more money versus just appeals on something or someone who's just in life without the death penalty? Would that be accurate?
The death penalty cases get a different kind of scrutiny.
I see.
It's actually harder for life without parole and lifers to get review. Not only courts don't often grant review, but also they don't have the pro bono resources.
I see. See, as a layman, I had no idea
that when your death penalty.
Yeah, the death penalty case is really that's what brings in the money and the PR. No one gets as excited about getting a guy off who's in life, but the death penalty gets everybody emotional.
Mm-hmm. Yeah. So he filed his petition for writ of certiorari on March 2nd, 2020. The question presented were whether a defendant advancing a Brady claim must demonstrate that he or she could not have uncovered the suppressed evidence through the exercise of due diligence, whether the materiality of a Brady claim must be determined by considering the probative force of the withheld evidence cumulatively and in the context of the government's entire case, and whether the Florida Supreme Court's error in treating petitioner's Giglio claim as though it alleged knowing use of perjury when it actually alleged withholding exculpatory evidence warrants reversal. And this was because basically in January, and I didn't have this when it happened, but when 2020 was doing their interviews, Matt Gutman interviewed the trial prosecutor, Robert Heyman, and he had notes from Dailey or perhaps from the court record, because they did request the entire record for both cases. And he showed those to Heyman and got Heyman to admit on camera that those were his notes. And there was a reference to sexual assault scratched out regarding Skalnick. Skalnick was charged but not tried and not convicted. The charge was dropped of an improper or lewd and lascivious behavior with a minor under 14 in Texas. But that was not pursued. It was dropped. So he was never convicted of it. And they claimed if they had known about this, they could have impeached Skalnick with it. But the jury's kind of out on that, because if he wasn't convicted, then you can't bring it up. The same thing applies as against a defendant. You can't bring in crimes that he's not been convicted of, even as impeachment. So, he was accused, but he was never convicted.
Mm-hmm.
So he wasn't lying when he said, I've never been convicted of sexual assault. But even if you look at stories now about Skalnick, it still claims that this was, a Brady violation.
Although people don't want facts to get in the way of
Yeah.
a good story. I mean, it's the same thing, like, the West Memphis 3 case, like, the state through this deal to Damian, Jason, and Jesse, it's and we know that's not true. It was flipped, but it seems that a lot of the, whether it's places like 2020, ID Discovery, whatever the case that covers it, or just your local newspaper, they seem to really like what the narrative is. It's what is going to be more appealing to the reader versus, we talked about it off the recording, that the days of reporting of just, we put the information, you decide, like, we don't really have that anymore. Everything is, you're catering to a perspective. You're catering to.
Oh, I'm sorry. I didn't mean to cut you off.
No, you're fine.
Well, I was going to say, too, I think I agree with you. And I think as a former journalist, I think part of it is, I think the average journalist today is just a fucking is a idiot. And they don't know. They're too stupid. Like, journalists used to be intelligent. Yes, they were biased. Yes, they had their, Walter Cronkite was biased, but they were intelligent, like smart people went into journalism. Today, if you can find a journalist with a triple-digit IQ, I'd be shocked. And I think some of it is bias, but a big piece of it is they're just so stupid. They don't know civics. They don't know how the justice system works. So they consume whatever a defense attorney or a lobbyist tells them, and they don't even question it because they lack the IQ to critically think. The average. Again, I'm sorry. You've hit a hot button with me, but the average journalist in this country is functionally mentally disabled.
Do you think that extends to the editors too?
Yeah, absolutely.
Yeah, because it's a party in that case. So I should have mentioned that as well. So yeah, that just kind of seems, but it seems like there is something now based on both stupidity and also to feed a narrative that I think is kind of commercially appealing to people, because unfortunately the news now, at least in my opinion, over the decades have become more entertainment. I think more than how it used to be. Before it was just, what is the news? What is the story? What's going on in our world, both locally, nationally, globally? And now it's just, depending on which news site you go to or what news cable channel you go to, it's what's my perspective? What do I like to hear? And that's where you get your information. And
yeah, exactly.
Yeah.
Right. I saw a story, a woman, and somewhere, I believe it was in California somewhere, she sees a guy in the Starbucks wearing a MAGA hat, and she just loses her mind. And she's swearing at him. She's calling him a Nazi. She's calling him a racist. She's trying to get everybody in the Starbucks to attack him. And first of all, it turns out that the people in the Starbucks didn't appreciate her behavior. And then she was posting on social media, and her employer found out, and her employer's like, this is not our message. No. So they let her go. But it's like we can't, a lot of us can't deal with different opinions.
Exactly.
We get too emotionally invested. And then some people just couldn't debate their way out of a paper bag if it, because all they know how to do is attack, bully, swear,
Yeah, you're so right.
scream.
Well, and they falsely
Well,
think that if you feel
yeah.
different, yeah, I was going to say, if you feel like the person feels like your opinion differs from them, it's almost like they're criminal. Like, an example, like, look, if I went into a store, or say I'm an employee of a store and some idiot comes in with a shirt that says Free Avery, in my mind, I'm going to roll my eyes and think, idiot. But I'm going to do my job. If I'm out at the bar or if I'm out at a restaurant, whatever the case may be, I'm going to like, that person's an idiot, but I'm going to be civil because what am I going to do? I'm going to start an argument. I'm going to ruin my night. I'm going to ruin my day.
Yeah.
Like I got that. But but a lot of other people feel differently. Like they feel that other opinions is almost criminal and you have to fight it. And it's
right.
It's ridiculous.
Well, no, absolutely. I mean, you look at all the backlash against Elon Musk. And I mean, Elon Musk went from a left-wing hero for inventing electric cars to now he's a pariah for his big crime is supporting free speech and not censoring diverse opinions. And they're losing their mind about it. It's crazy.
Yeah. And I've said this for years, is that a part of it is, and I encountered this with the West Memphis 3, they want to silence diverse opinions. So if I don't agree that Damian Eccles, Jason Baldwin, and Jesse Miss Kelly are innocent, then I need to be off the internet. I need to lose my job. I need to be canceled.
Right.
Because I don't see things the way they do.
Because your viewpoint is criminal. That's how they see it.
Yeah.
Well, I've told you guys this before. I mean, it's been a long time. Gosh, Lisa, probably when we first met. I mean, I was questioning fat, corrupt fireman's West Memphis Free stuff, and I literally had people like checking my LinkedIn profile, like looking at all kinds of stuff. I'm like, dude, it's just a discussion board. Like, why are you? I mean, they didn't do anything ultimately, but I know they were looking to threaten me if I continue to ask questions.
Yeah.
And that's, and not to go too off base, because I know we want to continue the discussion with what's the topic at hand, but I had people find my other YouTube account that's separate from anything. It's just what I watch my basic YouTube stuff on. Nothing bad, but they went into it, they published it. They're like, oh, look, he's watching this, he's watching that. And it's like, why? Why do you care? Like, why do you feel the need to publicize this? Kind of like if it's some kind of strike against me, but it's like, I'm not watching anything that would be considered, socially implorable. But why would you do it? Like, it's just let me know.
Yeah.
I see you. And it's creepy.
Yeah.
Well, the last thing I'll say is I think this is my own sort of interesting sort of psychological, philosophical pursuit. But I think as religion has declined in the U.S., I think a lot of people have made politics and these types of things their religion, and a lot of them are fundamentalists, and they just see it as their life's work. It's definitely insane. I agree with you all.
All right. So back to Dailey. But that's a conversation for another show. And we should do that. Okay, so there are reasons for granting the petition. The Brady violation may occur even if the defendant could have discovered and suppressed evidence through the exercise of, quote, due diligence, unquote. The defendant may rely on the government's assurance that exculpatory material has been disclosed. The courts of appeal and state courts of last resort are divided on whether Brady claims may be rejected for failure to exercise due diligence. 6 courts and several state courts of last resort follow Banks in rejecting a due diligence rule for Brady violations. 6 courts of appeal and 4 state courts of last resort, in addition to Florida Supreme Court, continue to recognize a due diligence exception to Brady's disclosure obligations. And I just want to say Brady is the buzzword, but Brady, the evidence has to be material to the question of guilt or innocence. If it's just material to impeaching a witness, it doesn't always pass muster. Which is basically what this would have been would be to impeaching Skalnick. The due diligence question is a recurring and significant one that warrants the court's attention. The court below misapplied both Brady requirement that evidence be considered cumulatively and the clear requirements of Giglio. The court below erred in not considering the suppressed evidence cumulatively and in context. The Florida Supreme Court misapplied Giglio. The cumulative effect of the suppressed evidence undermines confidence in the verdict. Given the clear nature of the errors committed below, summary reversal is warranted. The respondent's brief was filed on March 10th, 2020. Paul Skalnick died in Corsicana, Navarro County, Texas. And points to whoever recognizes the name Corsicana and can tell me the name of the case that came from Corsicana.
Hey, guys, do you hear the background?
I hear a dog.
I heard a dog barking, but that's okay because y'all probably heard creaking and
no.
stuff
Sorry,
while I was looking.
Okay, I'm gonna log out and come back in because I keep hearing the intro. I don't know what's happening.
Oh, okay. Well, do you want to take a stab at your points? Case from Corsicana, Texas. Big case. Oh.
Hey, sorry,
Okay.
I'm back. I kept hearing the intro playing.
Okay. Case from Corsicana, come on.
Can you give us a year? Give us
1990s.
1990s.
It was like 1993 or 92 or 94. Happened at Christmas.
Oh, I don't know. I'm terrible at game trivia.
Hey, Kyle? It's a case we have not covered yet. All right. Time's up. Cameron Willingham.
I'll see. I don't even know. I hate to say it.
I guess I need to cover that one then. All right. So anyway, the respondent's brief was filed, and the question presented, according from the state's perspective, hopefully Kyle will make it back. He's still hearing the intro music for some reason. Was whether the Florida Supreme Court erred in concluding that petitioner's third successive post-conviction motion does not meet the requirements of Rule 3.851. The state's reasons for denying the petition: this court has jurisdiction because the decision below rests on it. This court lacks jurisdiction because the decision below rests on an independent and adequate state ground. This case presents neither the conflict nor the split that Dailey alleges. The decision below is incorrect. The motion to delay distribution was filed by Dailey on May 19th, 2020. Let me bring Kyle back. How's it going, Kyle?
Sorry, I'm having phone and StreamYard problems in addition to coughing like an old smoker.
Oh, well, if you feel like you need to just,
I actually don't feel that bad. I just talking hurts, but I don't feel that bad. I'm just trying not to cough over the podcast.
Okay. So, like I said, if you start to feel like you're tired and ready to be done,
no, fair enough. Yeah, absolutely. I'll just
take care of yourself.
If I disappear, it'll be because of that.
Yeah. Okay. All right. Bless you for being here when you're under the weather. So Dailey filed a motion to delay distribution, which was granted, and the petition was distributed for conference on September 29th, 2020. The conference was held. The petition was denied on October 5th, 2020. Then Dailey's attorneys in October of 2019 filed a request to have additional clemency proceedings conducted on his behalf. They were requesting a second clemency proceeding because of the newly discovered evidence developed since October 2015, and alleges that this new evidence conclusively establishes Mr. Dailey's innocence. It also inescapably points to Jack Piercy and Jack Piercy alone as Shelley Boggio's killer. On the 30th of October, they provided records and documents and transcripts supporting Dailey's alleged, quote, strong claims of innocence, unquote. But the exhibits were not included with this particular letter. And then a letter to the Florida Commission on December 5th, 2019, providing additional, a New York Times article exposing Paul Skalnick as, quote, one of the most prolific jailhouse informants in U.S. history, unquote. Then he filed a successive petition for federal habeas corpus, or he went back to federal court on November 26, 2019, with a motion for miscellaneous relief to permit federal habeas corpus counsel to conduct state court litigation. The state opposed this. An expedited hearing was held on November 27, 2019, and then the motion for miscellaneous relief was granted on November 27, 2019. On November 30th, he filed a motion for relief from judgment, claiming fraud on the court. Dailey alleges that the state committed fraud when it impeached Shaw's testimony at the 2003 state court evidentiary hearing with his 1987 trial testimony because a newly discovered Indian Rocks beach report establishes that Shaw told Detective Halliday about Piercy's solo return to the house in May 1985. Motion for limited discovery and evidentiary hearing was also filed. Then he filed a second petition for habeas corpus on November 30th, and he basically challenging the clemency process in Florida, particularly as it applied to Dailey. He filed a motion for relief from judgment under a different rule of the Federal Rules of Civil Procedure, alleging ineffective assistance of counsel for failure to investigate and develop Dailey's Strickland claims during state post-conviction and conflict of interest, because Capital Collateral Regional Counsel representation of Dailey and his state and federal post-conviction claims created a conflict of interest. He filed a corrected second petition for writ of habeas corpus on the clemency claims on November 30th as well. An order was entered on December 2nd, 2019 before the court is Mr. Dailey's petition. The court directed the clerk of court to open a new civil case with this petition and corrected petition, and to docket a copy of this order with the new case file. Then there was an order denying stay of execution entered on December 2nd, 2019. And this one is important. I want to go through the whole court finding. This matter is before the court on Petitioner James Dailey's motion for a temporary stay of federal habeas proceedings pending 11th Circuit's disposition of Collins versus Secretary, in which he moves the court to stay his execution pending the resolution of Collins versus Secretary, Florida Department of Corrections. This court denies the motion. This court has reviewed the entire record of this matter closely. The entire record does not suggest that the actual innocence of Mr. Dailey. Although only two persons alive know for certain what happened at Lover's Lane area that night where Mr. Dailey had visited prior, the entire record here suggests the state had a sufficient case against Mr. Dailey and the jury returned a rational verdict. The trial transcript of the two jailhouse informants, or two jailhouse librarians who passed and surreptitiously Xerox notes between Dailey and co-defendant Piercy, Dailey's flight to Miami the next morning after visiting a laundromat and car wash, and eventual flight to Tucson, Arizona, were an important part of the state's case. The bar hopping and marijuana smoking with the 14-year-old victim and her dancing with Piercy but rebuffing the 40-year-old Dailey is notable. Mr. Dailey's early morning appearance back at the house with trousers wet in the crotch area and no shirt, carrying a bundle, remains inexplicable. yet it is consistent with someone holding a bled-out girl underwater to drown. Dailey's post-trial testimony about his wet pants strains credulity. Dailey testified that Piercy retrieved Dailey from bed sometime in the early morning hours after the day of drinking and marijuana smoking to go out to the Bel Air Causeway for more imbibing. And there, Mr. Dailey threw a frisbee first with himself and then with Piercy, becoming wet when he retrieved it from the water. Additionally, the motion suggests as part of the actual innocence claim that the co-defendant Piercy confessed that Piercy alone committed the murder. This is not accurate. While Mr. Dailey's counsel did file a Piercy affidavit to that effect in this record, when Piercy was examined in the evidentiary hearing, he receded from any such claim. Beyond that, any suggestion that Piercy is a credible witness is a stretch. Over the years, Piercy has changed his account of what happened that night numerous times. And even then, Piercy has never testified while under oath and subject to cross-examination that Mr. Dailey was not involved in the murder, despite seemingly no incentive to withhold exculpatory information. Each time Mr. Dailey's counsel has called him to testify about the newly discovered evidence of his signed affidavits, he has either refused to testify or said the affidavit was not accurate. Accordingly, even if the 11th Circuit were to recognize actual innocence as a federal habeas claim, Mr. Dailey is unlikely to be able to meet the high burden. Thus, the motion is denied with prejudice. And then his second federal habeas claim, basically challenging Florida's clemency proceeding, was dismissed on December 5th, 2019. And basically, it was because under 2254, petitioner under 2254 cannot be brought to challenge the process by which clemency decisions are made when issuance of a writ would not actually or impliedly invalidate a sentence. So Mr. Dailey is challenging the constitutionality of Florida's clemency proceedings. This claim is not cognizable in a habeas proceeding under 2254. I'm guessing that if a new date is set, they're going to file a 1983 claim challenging Florida's clemency. And hopefully that will be quickly dismissed because they knew that that's the avenue they needed to follow in 2019. Anyway, the petition for habeas corpus was thus dismissed. The state had filed a motion to dismiss, which was denied as moot, and Dailey filed a motion to reconsider, and that motion for discovery was denied, and evidentiary hearing were denied, and then the court entered a memorandum order on his motions for relief and basically denied or dismissed them, and said Dailey asked this court to undertake a, quote, holistic analysis of the facts and circumstances to determine whether relief is warranted, unquote. Although it is not the court's province at this stage, 34 years later, to adjudicate evidentiary sufficiency and retry the case, the court has personally read every single page of this lengthy record. A thorough review shows the state's trial case against Dailey was not strong, but it was sufficient. It was made stronger by several acts by Dailey, such as his physical appearance after the murder, his inexplicable flight to Miami, and his jailhouse correspondence with Piercy. Dailey's defense is further marred by his implausible post-trial testimony, which sought to explain this unusual flight and to explain Dailey's appearance after the murder. This is not the place or remedy to restate the case against Dailey and weigh why he is facing the death penalty. The court here provides but two examples of misguided points made by Mr. Dailey in his selective portrayal of the record. First, in several of his later motions, Mr. Dailey cites a 2017 affidavit of co-defendant Piercy that states Piercy alone and not Dailey murdered the victim. The affidavit is typical of latter-day exculpatory affidavits seen on occasion from co-defendants. It was created by Dailey's able lawyers for this purpose, and in it, Piercy promised to testify as to the exculpation of Dailey. Fortunately, the state court took up Piercy's promise and held an evidentiary hearing on this 2017 affidavit. There, Piercy, in person, entirely failed to substantiate its truth and took the Fifth Amendment as to all the merits of the affidavit. Yet Dailey touts this affidavit now. The 2017 affidavit is an item of sworn Piercy hearsay in this record, which Piercy declined to substantiate from the witness box. But if one were to consider sworn hearsay statements in this record of Mr. Piercy, a more apt selection might be his 40-page sworn statement in June 1985 during the state's attorney investigation. In that statement, soon after the crime, Piercy explained the details of the murder. He explained in detail how Dailey butchered and drowned the 7th-grade girl during a rape. Piercy denied stabbing or assaulting the victim, admitting his participation later. Piercy's statements in that lengthy sworn interview are consistent with physical facts of the case, even down to the vomit that he admitted upon seeing the slaughter, which was found the next day near where the victim bled. Both the 1985 sworn statement and the 2017 affidavit now touted by Dailey are not admissible at a criminal trial. But surely the former, more contemporaneous by 32 years, has equal or greater salience in a holistic analysis of the facts and circumstances on this record as requested by Dailey. The court offers a second example of how a holistic review of this record urged by Dailey does not help him much. Mr. Dailey's counsel have decided the use of has decried the use of jailhouse informant testimony. That type of testimony is often fraught with problems and, in the undersigned's view, is too frequent in criminal prosecutions. But the testimony of the 2 jail librarian informants was backed up by 4 notes they passed at Dailey and Piercy's request. Those notes are in Dailey and Piercy's hand. The trial judge admitted as evidence the notes written by Dailey. All 4 notes are present in this record and should be considered as part of any, quote, holistic review, end quote. The 4 items inculpate Mr. Dailey. They are consistent with co-actors, partners, as Dailey says in one note, who are trying to game their respective trials. One of Piercy's notes expressly implicates Dailey as murderer, consistent with Piercy's SAO statement. The notes in Dailey's hands are inculpatory and inconsistent with the facts as he now portrays them. And these contemporaneous notes are entirely consistent with and well buttress the librarian's damning trial testimony. So Dailey's motions were denied. He filed a notice of appeal to the 11th Circuit Court of Appeal. On February 5th, 2020, a motion for COA was denied, so there was no appeal. He also filed an application for leave to file a successive habeas petition in the 11th Circuit, claiming actual innocence, Brady violations, and ineffective assistance of counsel, and not obtaining Kansas interview tapes. The Court of Appeal issued an opinion holding in a murder case defendant was not entitled to file a successive federal habeas petition because he failed to make a prima facie showing of actual innocence under 28 U.S.C. 2244B3C based on new evidence casting doubt on the credibility of an informant as there remained substantial unrefuted evidence of his guilt. Defendant's application failed to show that he could not have discovered the police report or letters that form the basis of his Brady claim had he exercised due diligence before he filed his first habeas petition. Therefore, he did not meet the requirements of 28 U.S.C. 2244 B2BI to show that the actual predicates for the claim could not have been discovered previously. So the petition was denied. And now we go back to state court, and he filed a second successive motion to vacate after death warrant signed, which is his 4th overall state motion for post-conviction relief on December 27, 2019. He claimed newly discovered evidence, a December 18, 2019 declaration of Jack Piercy, proving Dailey was innocent and that Jack Piercy alone murdered Shelley Boggio. taken together all the newly discovered evidence so weakens the state's case against Dailey as to give rise to reasonable doubt as to his culpability. The evidence presented at trial and discovered in post-conviction proceedings corroborates Jack Piercy's claim that he was the sole actor in Shelley Boggio's murder. Additional evidence discovered in post-conviction proceedings has eviscerated the case against Dailey and strongly supports his claims of innocence, and Dailey has established that all of the evidence considered holistically would probably produce an acquittal at retrial. The state responded on January 16, 2020, and in its response said, over the last 25 years, Dailey has raised post-conviction claims concerning Piercy and has alleged that Piercy would testify during an evidentiary hearing that he was responsible for Shelley's murder. Dailey was given 2 full post-conviction evidentiary hearings to prove this post-conviction claim, along with 2 rounds of appeals to litigate this issue. Now Dailey seeks a third bite at the same apple. There is no provision under Florida law that allows Dailey to continue to return to court to present this claim all over again in an effort to see whether Piercy will finally testify. As established above, Dailey's claim is untimely, procedurally barred, and does not, under any circumstances, constitute newly discovered evidence. Although Dailey's successive motion should be summarily denied for the reasons set forth in this response, in an abundance of caution, the state does not object to an evidentiary hearing for the limited purpose of addressing Jack Piercy's latest declaration. Dailey filed a motion to substitute on January 21st, a motion to amend, rather, on January 21st, 2020, to add a newly discovered evidence claim and a fraud on the court claim. Based on the fraud on the court, I think was Hayman's notes. The newly discovered evidence established that Dailey is actually innocent and that Jack Piercy is solely responsible. And this is based on the January 14th, 2020 statement of Hayman, establishes that Dailey's trial prosecutor had actual knowledge of Skalnick's prior child sexual assault charge, but allowed Skalnick's false testimony to stand uncorroborated, and that newly discovered evidence establishes that trial prosecutor Robert Hayman committed fraud upon the court. Okay, so it was all based on the trial notes, which they used 2020 to get Hayman on the record or on video saying, yes, those are my notes. So I'm frankly surprised that 2020 has not gone to bat for Richard Glossop in all these years. And we'll talk about my experience with 2020 another time. I don't want to open that can of worms right now.
Is Glossop still waiting? Is he still hanging on?
Yeah, well, the U.S. Supreme Court has not rendered its decision yet. That was argued in October, I believe.
Yeah.
So we're still waiting on a U.S. Supreme Court decision.
And Rodney Reed is still waiting, right? Like, we're still waiting on all this stuff.
Only one of Rodney Reed's claims remains. The case was returned to the Fifth Circuit. The DNA challenge to the denial of DNA testing, civil rights claim, was returned to the Fifth Circuit by the U.S. Supreme Court.
Right.
And we're awaiting the Fifth Circuit's ruling. That was argued in September.
Gotcha.
And the argument in September did not sound like it was going Rodney Reed's way.
No, I can't imagine. I mean,
so. All right. So, motion to amend was granted on February 4th. The state filed an additional response on February 17th. A case management conference was held on February 20th. An order was entered on February 20th granting an evidentiary hearing on Claim 1A, a claim that the declaration of Jack Piercy shows that Piercy committed the murder by himself, and granting defendant's request to depose Piercy prior to the hearing. On February 25th, 2020, the deposition of Jack Piercy was held, although a lot of these Innocence Project attorneys are also snakes.
Yeah.
And I say this because when they do the process wrong, and then when the court won't give them what they want, they say, well, the state didn't say anything. The state didn't object. The state didn't argue against it. It's like they didn't have to. They're arguing against it now. But that's getting ahead of myself. So they held that at February 25th, 2020 was the deposition was taken. Then they filed a motion to prohibit witness interference on February 25th, 2020. They claim that the state attorney's office has a history of interfering with witnesses who have evidence favorable to Dailey's claims of innocence. And they cited alleged interference with James Slater, James Leitner, and Jack Piercy. That the state attorney's office has interfered with witnesses in present proceedings, interfering with Jack Piercy's family, and interfering with defense counsel's ability to meet with Jack Piercy because the Department of Corrections rejected a request for them to interview Jack Piercy. They don't represent him. And the Department of Corrections said, yeah, no, we're not going to let you visit him anymore. And they sought the court should prohibit the state from interfering with Mr. Piercy's ability to testify truthfully, whether directly or by way of Piercy's family. And the court should require the state to proffer Mr. Piercy's mother's testimony. Now, the state addressed in a response the claims made in this motion on March 4th, 2020. And basically, they provided a complete rebuttal. I'm not going to go into the complete rebuttal other than they pointed out that they didn't do anything wrong in what they did in their, preparing their case or preparing their response to Dailey's case. The evidentiary hearing was held on May 5th, 2020. And this is, I'm quoting directly from statements made by Piercy during that hearing. First, he said, in that statement I made, which I think may be the 1985 statement, I said what happened. I made an original statement when I turned myself in. Later, he says, okay, at the end of that statement, I said 3 hours. We done questions and asked and answered. They asked everything they wanted. And at the end, I said exactly what happened, that I didn't kill Shelley, whatnot. And that's all. I really don't plan on testifying further. I think he's referring to the deposition there. Because in the deposition, I don't think he ever said he killed Shelley. Mr. Piercy also said, in that depo you have right there, and in the original statement when I turned myself in, and all the forensic stuff backed it up. That's where Joan Wood started and Holiday come out and the one-line confession. All of that was after. That original statement, all the forensic stuff, that couldn't be changed. Even Joan Wood trying to change her autopsy, all of that came later. And I think these were in response to questions Dubin was asking him. Finally, Piercy said, sir, I've done 35 years for a crime I didn't commit, and I don't plan on testifying against somebody else to help the state kill them, and that would be all my testimony could basically do, so I have nothing else to say. I did that 3-hour depo and asked and answered all their questions. I don't have nothing further to say on the subject. So that was the end of Jack Piercy's appearance on May 5th, 2020. On May 5th, 2020, March 5th, 2020, pardon me, the court also entered on the record a denial of the motion to prohibit witness interference. And this is what he said. All right, all I've heard is innuendos today. I don't see any evidence that the state has interfered, and I'm not going to make a finding that they interfered in any way or intimidated any witness. So he denied the motion to prohibit. On the same day, he issued an order denying or granting a request for emails between Piercy and his mother, sent or received between February 19th and February 24th, and copies of calls between February 19th and February 24th. He declared the request for calls between Piercy and the state attorney's office moot, as the Florida Department of Correction did not possess any calls. And he also found that Piercy's visitation logs had been provided to Dailey's counsel. He entered a second order on production of public records, requiring production of calls between Piercy and his mother, Sally Simon, between December 27th and January 18th, 2020. Then he ordered audio recordings of Piercy's deposition to be produced by the state, and found that the remaining documents requested were exempt as work product and do not contain Brady material, and that the material in the state's current file relating to the instant motion for post-conviction relief may be exempt as work product because there is ongoing litigation with respect to such documents. And then on May 12th, 2020, he entered another order denying an emergency demand for additional public records, which sought copies of telephone calls and emails between Piercy and his mother, sister, stepfather, son, and daughter-in-law prior to the 2018 and 2020 hearings. Written closing arguments were filed by Dailey and the state. Dailey's was 72 pages, and the state was 12 pages. Then he entered on May 29th an order denying in part and dismissing in part defendant's second successive motion. And he found that as to Piercy's confession claims 1A and 1B, with or without the deposition, there is no new admissible evidence that Piercy has confessed to committing the murder by himself. Mr. Piercy did not testify at the evidentiary hearing, and all new evidence that he confessed to Attorney Dubin or in an affidavit is inadmissible hearsay. Evidence must be admissible to be newly discovered evidence. Hearsay testimony is generally not admissible absent an exception, and hearsay within hearsay is admissible only if there is an exception for each portion of the testimony. In Dailey 5, the Florida Supreme Court agreed with this court that a prior affidavit from Mr. Piercy was inadmissible hearsay. The Florida Supreme Court rejected the argument that it was admissible as a statement against interest because Mr. Piercy does not expose himself to any additional criminal liability by accepting responsibility for the murder. The court also rejected the argument that it was admissible under Chambers v. Mississippi because the affidavit was executed long after the crime occurred, was not unquestionably against Mr. Piercy's interest, and is of questionable truth because Mr. Piercy has disavowed its contents. As no live testimony was offered at the hearing, the only possible evidence for the claim is Mr. Piercy's affidavit, Mr. Piercy's out-of-court statements to Attorney Dubin, and Mr. Piercy's deposition. Dailey 5 clearly forecloses admitting Mr. Piercy's affidavit. The affidavit here is, for the purposes of admissibility, virtually identical to the 2017 affidavit. Just like the prior affidavit, this affidavit was signed long after the crime occurred and is not unquestionably against Mr. Piercy's interest. In addition to his previous inconsistencies regarding his involvement in the crime, Mr. Piercy again denied the truth of the statements in the affidavit in his deposition. Piercy's deposition did not give the state an opportunity to cross-examine him, as explained more thoroughly below. The deposition was only a discovery deposition, and the state had no notice that it should cross-examine Mr. Piercy. The same analysis applies to Mr. Piercy's out-of-court statements to Attorney Dubin, which were made at a similar time, were also denied by Mr. Piercy and are not unquestionably against Mr. Piercy's interest. The fact that Mr. Piercy admitted to making these statements in a deposition is hearsay within hearsay. It is still inadmissible, absent exceptions for both portions of the testimony. The remainder of the deposition, where admissible, does nothing to support this claim. Again, in the deposition, Mr. Piercy repeatedly denies the truth of his prior confession. There may be grounds for defendant to attack Mr. Piercy's credibility, but that does not produce any evidence that defendant could introduce to his benefit at a new trial. Defendant's burden is not to show that Mr. Piercy lacked credibility. Defendant's burden is to show that Mr. Piercy's confession is admissible, is newly discovered, and would have a reasonable probability of changing the outcome. Defendant has not done so. His motion, therefore, must be denied. And then he addresses whether Piercy's deposition is admissible and finds in some defendant failed to follow the procedure outlined by case law for requesting a deposition to perpetuate testimony. Additionally, the state had no notice that the deposition might be used as substantive evidence and therefore little motive to cross-examine Mr. Piercy. The deposition is therefore not admissible as former testimony. He also found that the newly discovered evidence claims failed. And I'm not going to go into that. Although I will say he never amended the motion with claims relating to Piercy's deposition. So many of the arguments made at the evidentiary hearing, which attempted to show that Mr. Piercy's statements during his deposition demonstrate that the defendant was not with the victim at the time of death, have nothing to do with the confession in the December 18th declaration. Defendant cannot advance new claims for the first time at an evidentiary hearing. The court will therefore not consider those arguments in this proceeding. And that's like a simple court rule. If you're going to be taking a deposition to enter it as testimony at a trial, that's a separate process. If you notice a deposition, it's for discovery generally. But it's not meant to take the place of trial testimony. And they should have known that, but I think that they wanted to rely on the declaration and the affidavit, and they kind of are butthurt that the court is making them produce Jack Piercy to testify at all. And then he addressed claims 1C and 2, and those were basically procedurally barred because they were substantially the same as the claims made in 2017 as to Skalnick. And then he found regardless if these claims were timely, they would be denied because, as the Florida Supreme Court has already held, Mr. Skalnick's prior charge is not material. When defendant appealed the order on his 2017 motion for post-conviction relief, the Florida Supreme Court found that regardless of whether defendant could establish the other prongs of Giglio, Mr. Skalnick's testimony regarding his lack of physical violence was not material. The court reached this conclusion assuming defendant met the other prongs. That is, it assumed the testimony was false and that the prosecutor knew. So the jury was already aware that Mr. Skalnick had committed multiple crimes. If these claims were timely, they would therefore be denied. So the court denied claims 1A and B and then dismissed claims 1C and 2. Dailey appealed to the Florida Supreme Court, and the court entered a briefing schedule on July 23rd, 2020. And then what does he do? On July 31st, 2020, he files a third successive motion to vacate judgment of conviction and sentence of death after death warrant signed on July 31st, 2020. And also filed a request to toll time on the same date and a motion to relinquish jurisdiction, seeking to go back to the state trial court. The state filed a response to the motion. Oh, let me go back. The Florida Supreme Court granted the motion to toll time on August 4th, pending resolution of the motion to relinquish jurisdiction. The state filed its response to the motion to relinquish jurisdiction. And again, I think this bears repeating at least a part of it. The state argued that Dailey's fifth successive motion is frivolous and serves no legitimate purpose other than to create unnecessarily delay to the resolution of his claims. Dailey's newly discovered claim in his fifth successive motion alleges that during Piercy's 2020 discovery deposition, Piercy admitted for the first time that he went out drinking alone with Shelley Boggio on the night she was murdered, immediately after dropping his friend Oza Shaw at a phone booth. Piercy clearly did not make that statement for the first time during the 2020 deposition, and even Dailey acknowledges as much in a footnote, stating Piercy originally referenced the solo outing with Boggio in a statement to police on June 19, 1985. In fact, Piercy indicated he was alone with Shelley after dropping Shaw off at the phone booth in his 1993 sworn statement, as well as his 1985 statement. Piercy refers to his previous sworn statements throughout his 2020 deposition and repeatedly states his desire to rely on those past statements when the facts were fresh in his memory. Piercy's 2020 discovery deposition clearly does not constitute newly discovered evidence for Dailey. And then it goes on, basically Piercy kind of, every time he testifies under oath, either in court or a deposition, he kind of backs away from whatever his written declarations or affidavits have said. It strains credulity that Dailey's attorneys have alleged newly discovered evidence based on this deposition testimony, and that they want to obtain additional sworn testimony from Piercy in spite of his admitted motivational lie and his willingness to commit perjury. Piercy has stated that he has repeatedly told lies to prevent Dailey's execution and to further his own interest in having Dailey's attorney uncover newly discovered evidence that Piercy could use to challenge his own conviction and sentence. As such, Piercy has signed whatever documents Dailey's attorneys have provided to him, regardless of their truth, and he is willing to lie to delay Dailey's execution. There comes a point where enough is enough. The state submits that we are past the point with Dailey Piercy claims. Dailey has been permitted to raise and litigate newly discovered evidence claims regarding Piercy for 2 decades. There comes a point where it becomes hard to reconcile how Dailey keeps being allowed to litigate and relitigate claims based on Jack Piercy when they do not actually constitute newly discovered evidence. Meanwhile, Shelley Boggio's family is left not only without closure, but they are having to relive their tragedy over and over again each time the case is brought back before the trial court. Enough is enough. On August 21st, 2020, the motion to relinquish jurisdiction was granted, and the parties were directed to file status reports while the state court, sorry, that's a Walmart order at some stage. So then the third successive motion to vacate
sounded
after
like
death
a plane
warrant.
crash. Are you okay? I was like, my goodness, what's happening?
That's a bomb dropping.
I thought it was a firework, like a shooting rocket or something. They're shooting it off at my house. No, they're shooting it off by my house too. I'm surprised you guys didn't hear it.
Oh yeah, I don't hear them. I think our houses are pretty well insulated.
So wait, is there a holiday?
Who's
loud? Shooting fireworks today?
They will continue shooting fireworks until they run out.
Oh.
Yeah. Oh yeah.
And I've seen some stands will stay open until after the first weekend in January because they make money. So, all right. So basically, the claims raised in the third successive motion alleging exculpatory testimony from Piercy's February 2020 deposition constitutes newly discovered evidence. Piercy's recently discovered evidence viewed cumulatively destroys any remaining confidence in the verdict, and they make various arguments with regard to that. And at the minimum, they argue that Piercy's February 2020 deposition testimony warrants the vacatur of Dailey's sentence. They request leave to amend the motion should new claims, facts, or legal precedent become available, that they be granted an evidentiary hearing, that Dailey's conviction and sentence be vacated, and any other relief the court deems appropriate. They filed a motion for leave to depose Jack Piercy to perpetuate his testimony for a hearing on July 31st, 2020. And that was supported by an affidavit by Josh Dubin, signed on July 31st, 2020, alleging Piercy's unavailable to testify in open court because when he's called into open court, he pleads the fifth. That his testimony is material to the claim of newly discovered evidence set forth in the third successive motion. that Mr. Piercy is the only known and undisputed eyewitness to the murder of Shelley Boggio and therefore possesses vital information relating Mr. Dailey's innocence. Among other information, Piercy possesses firsthand knowledge related to the newly discovered evidence claim raised in the third successive motion. The newly discovered evidence claim is based on Piercy's testimony at the February 25th, 2020 deposition that Mr. Piercy and Shelley Boggio went out drinking alone immediately after dropping Mr. Piercy's friend Oza Shaw at a phone booth. They argue that Piercy is unavailable to testify at a hearing, so they want to take a deposition, although I don't think a deposition will be any different. They argue that despite Mr. Piercy's persistent refusal to testify in open court, Mr. Piercy has repeatedly demonstrated a willingness outside the courtroom to, one, admit he alone murdered Shelley Boggio, and two, otherwise testify orally by way of deposition or sworn statement regarding various other details with respect to the night of the killing. And so they requested that they be allowed to take Piercy's deposition. They filed a motion to stay and hold in abeyance on July 31st, 2020. The motion for stay was granted on August 13th, 2020. The state filed an answer alleging that the motion was untimely and procedurally barred, improper, and without merit. And again, they said there comes a point when enough is enough, and basically repeated the arguments. One of the arguments they made was that Dailey's attorneys now definitively know that Piercy has signed each and every affidavit they provided him, regardless of their truth, and Piercy has admitted that he has told them what he thought they wanted to hear in order to keep Dailey's case alive. There is absolutely no basis under which Florida law supports the continuation of litigation of Dailey's Piercy claims under these circumstances. And it's, again, enough is enough. The fifth successive motion is untimely, procedurally barred, and abuse of process. Dailey filed a memorandum of law in further support of the third successive motion and in opposition to the state's motion to dismiss on August 31st. On September 21st, 2020, the court dismissed the third successive motion without a hearing. It found the motion was untimely. As the purpose of this deposition would be to prepare for an evidentiary hearing on the motion that is dismissed in this order, this motion to perpetuate is moot and is therefore dismissed. In an abundance of caution, however, the court finds that defendant would not be entitled to take such a deposition at this time regardless. In Reitman v. State, a post-conviction defendant moved to take a deposition to perpetuate testimony of a witness living in Dubai. The state objected, among other reasons, because the parties did not know the witness's location. The trial court denied the motion without prejudice should the witness later be located. The Florida Supreme Court affirmed and noted that the trial court did not abuse its discretion in denying the motion due to the fact that counsel did not know where the witness was located. The instant motion to perpetuate testimony is similarly speculative. Counsel does not know that, should the court allow this deposition and the parties attend, Mr. Piercy will even be willing to testify. This court has already conducted multiple evidentiary hearings to allow defendant an opportunity to present Mr. Piercy's testimony, and he has refused to give it, despite the efforts of this court. While the court is sympathetic to the fact that Mr. Piercy is outside of defendant's control, defendant is not entitled to yet another proceeding on speculation that Mr. Piercy will behave differently this time. Accordingly, it is ordered and adjudged that defendant's third successive motion to vacate of judgment of conviction and sentence of death after death warrant signed, and defendant's motion to take a deposition to perpetuate the testimony of Jack Piercy are hereby dismissed. Dailey filed a notice of appeal on October 20th, 2020, which went to the Florida Supreme Court. An unopposed motion to consolidate the first appeal and the second appeal was filed by Dailey, and that was granted. And then on November 12th, 2020, the court set a briefing schedule. There were several motions and orders to file additional documents and corrections to the record and to supplement the record from the trial court. The initial briefs were filed. The initial brief by Dailey was filed on January 13th, 2021. So again, this is a process that took some time. The state filed a motion to strike Dailey's initial brief on January 19th, 2021, because Dailey included news articles about his case in an effort to bring extraneous information and opinion that has not been established as evidence to this court's attention, nor should he be authorized to file a brief containing inappropriate argument. Dailey filed an unopposed motion to amend the brief and filed an amended initial brief, which was also stricken. The first initial brief was stricken. The state filed an opposition response to the motion to amend. And again, it was the arguments in the motion to amend, which was unopposed, were that the state agreed to everything in the first brief. So they're kind of, like I said, they're snakes. They're tricky, especially Dubin. You try to grab Dubin and he's so oily, he slips right out of your fingers. All right, so on January 29th, 2021, the appellee's unopposed motion to total time for filing appellee's answer brief was granted, and the time for filing said brief was told, pending state's motion to strike initial brief and appellant's motion to amend. Dailey filed a response to the motion to strike on February 3rd, 2021. An order was entered on February 16th, 2021, granting the motion to strike and denying the unopposed motion to amend, and ordering that the amended initial brief be filed, or the initial brief be filed before March 3rd, 2021. Which fully complies with appellate court rules. Then let's see. Florida Conference of Catholic Bishops had filed a motion for leave to file amicus briefs, which was denied on February 19th, 2021. Dailey's amended initial brief was filed, and he basically was raising all of the arguments raised in his two successive motions to vacate. The state filed their answer brief, which they countered Dailey's arguments. I'm not going to go into those. Dailey filed a reply brief, and on March 30th, 2021, the court filed an order that the case had been submitted without oral argument. On September 23rd, 2021, a per curiam opinion was entered or delivered, holding on appeal a prisoner under sentence of death challenging the circuit court's orders regarding his fourth and fifth successive motions for post-conviction relief and dismissing his motion to perpetuate testimony of a witness. The trial court did not err in denying his claim that testimony the witness provided at his 2020 deposition constituted newly discovered evidence establishing that the prisoner could not have been present at the time and place of the victim's death because the alleged new information was known to the prisoner since 1985 or 1993. 2, there was no abuse of discretion in the dismissal of the motion to perpetuate as moot because the purpose of the deposition would have been to prepare for an evidentiary hearing on the fifth successive motion, which was dismissed. So the trial court's orders were affirmed. There was additional analysis of some of Dailey's claims, and basically they found that the trial court did not err in dismissing the claim as to Heyman's quote admission as untimely and procedurally barred because it's merely a repackaging of the claim in Dailey's 2017 successive motion that Giglio was violated based on Skalnick's false testimony about his criminal history at Dailey's trial. More timely and not barred, it is without merit because information regarding Skalnick's lewd and lascivious assault charge is immaterial under Giglio. There is still no reasonable possibility that information regarding Skalnick's lewd and lascivious assault charge would have affected the jury's verdict. Hayman's notes have no impact on the materiality of Skalnick's testimony. Thus, Dailey cannot meet the Giglio materiality prong and is therefore not entitled to relief on the merits of this claim. And then it also dismissed claims about the 2019 declaration and the 2020 deposition. And so that was basically it. It found on the cumulative error claims that the trial court was correct that any alleged newly discovered evidence must be admissible, not only to satisfy the newly discovered evidence standard and constitute newly discovered evidence under the law, but also to warrant a cumulative review of the evidence. As discussed above, the trial court correctly concluded that any new claims that Piercy committed the murder alone based on his 2019 declaration and 2020 deposition are inadmissible and therefore do not constitute newly discovered evidence or warrant a cumulative analysis. The same is true for Hayman's admission, which would also be inadmissible at a retrial, as explained above. Because each of Dailey's claims failed, he was not entitled to a cumulative review of the evidence. Now, there was a single judge dissenting from this opinion, and he basically is just kind of repeating the defense narrative. The confidence in Dailey's conviction and sentence is further compromised. He addresses the use of informant testimony, ignoring the context of it. And then he alleges the confidence in Dailey's conviction and sentence is further compromised by the conflicting statements of co-defendant Jack Piercy, who, although he later denied it, admitted in 2019 to being solely responsible for Boggio's murder. Piercy, who was tried first, convicted of first-degree murder and sentenced to life imprisonment, executed a declaration where he stated, James Dailey had nothing to do with the murder of Shelley Boggio. I committed the crime alone. James Dailey was back at the house when I drove Shelley Boggio to the place where I ultimately killed her. Although Piercy later refused to repeat his confession during his deposition and during the evidentiary hearing on Dailey's claims, his admission to being solely responsible for Boggio's murder, coupled with a lack of substantial independent evidence to corroborate the testimony of the jailhouse informants, sufficiently compromises Dailey's conviction and the application of the death sentence. Ironically, Piercy, who was convicted by a jury of the murder of Shelley Boggio and who thereafter confessed to the murder and stated that Dailey was not involved, received a life sentence, while Dailey, convicted in no small part due to the testimony of those inmates and without substantial independent evidence, is facing the death penalty. While finality in judicial proceedings is important to the function of the judicial branch, that interest can never overwhelm the imperative that the death penalty not be wrongly imposed. Since Florida reinstated the death penalty in 1972, 30 people have been exonerated from death row. And that's according to the Death Penalty Information Center, who say that some people who were never exonerated were exonerated. 30 people would have eventually been put to death for murders they did not commit. The number of exonerations, the highest in the nation, I thought that was supposed to be Texas, affirms why it is so important to get the case right. And I bet you a judge in some other state will say it's New York. So Dailey filed a motion for hearing and clarification, which was denied on December 2nd, 2021. The mandate issued on December 21st. Another order on notice of delay was filed on December 21st. The opinion was released for publication on December 22nd. Dailey filed a petition for writ with the U.S. Supreme Court. First, he filed an extension of time request, which was granted, and then his petition was filed on April 29, 2022. And the questions were presented were whether the state's knowing use of perjury is relevant to determining whether the perjured testimony was material to the verdict, whether perjured testimony that the state knowingly used must be deemed material to the verdict so long as there's any reasonable likelihood that the false testimony could have affected the judgment of the jury. A motion for leave to file amici brief was filed by exonerees in support of petitioner. An order was entered granting state's request for extension of time to respond. The state filed its brief, and it framed the question presented as whether the Florida Supreme Court's holding that petitioner's second Giglio claim is procedurally barred and untimely under the Florida rules of criminal procedure is an adequate and independent state law ground supporting the judgment, and whether the Florida Supreme Court correctly concluded that considering all the facts, petitioner's newly discovered evidence regarding the prosecutor's alleged knowledge of purportedly false testimony did not warrant changing the 2019 conclusion that petitioner had no valid Giglio claim. Dailey filed a reply on August 23, 2022. Conference was held on September 28, 2022. On October 3rd, the amici brief was motion for leave was granted, and on October 3rd, the petition was denied. And now we are at the end. So that's the end of the legal challenges. Nothing has been done since, but there are a few miscellaneous things to talk about. First, there was a 2020 episode called "The Perfect Liar," which was aired on October 23rd, 2020. It was kind of a typical 2020 where you think they're going to be
objective.
Thank you. That was the word I was looking for. And then they turn and they start providing irrelevant information about a witness or an alternate suspect. They didn't really address, though, I guess they must have gone to production before the May hearing, because they didn't really address that, nor have they followed up on that, where Piercy comes in and not only refuses to testify, but says Dailey's guilty, or that he's not guilty, that Piercy's not guilty. The state issued a new execution by lethal injection procedure on March 10th, 2023. It's done by the Department of Correction, and it superseded procedure in place as of May 6th, 2021. The state certified that procedure and then sent it to the governor, and also the state filed that into the record on March 13th, 2023. On May 4th, 2023, Sheldon Johnson, a client of Josh Dubin, was released early from Sing Sing after serving 25 years of a 50-year sentence. From what I could find, he was not exonerated of the original crime, which was attempted murder. But I'll do a little bit more digging on Mr. Johnson. And then on March 5th, 2024, former Dubin client Sheldon Johnson Jr., age 48, murdered Colin Small. Johnson was found inside the apartment when New York NYPD performed a wellness check. Johnson claimed that Small had, quote, gone upstate, unquote. Johnson was taken into custody after a search recovered human body parts later identified as belonging to Small in the apartment. Johnson was recorded by surveillance cameras going in and out of the building, and a Tyvek suit was discovered in Johnson's car. Johnson was charged with small murder as well as manslaughter, weapon possession, and concealment of a corpse. So that looks like a very interesting case to look at down the road. And then additional attorney enrolled for Dailey. They submitted a demand for additional public records seeking medical records of Dailey between January 1st, 2022 to the present. That's probably going to be to try and argue against his execution or lethal injection procedures once a new execution date is set. The state filed notice of complying with the records request and filing confidential records in the repository and sending non-confidential records to Dailey's counsel on June 28, 2024. And that's the last activity in the case.
To rewind, I have a question. The Florida Conference of Catholic Bishops, how often do they get involved in these death penalty cases? Do you know?
I would imagine that since Pope Francis came out very strongly against capital punishment, probably any Florida case.
And do you think that's basically what their primary argument is just strictly about the death penalty? Have they, because I don't know if they made any kind of feelings or thoughts about his innocence or guilt, or innocence in this case. I know they were mentioned, and I think they were mentioned in that 2020 episode. It's been a couple of weeks since I've watched it.
I honestly, I didn't look at their amici briefs because I have about, I want to say about 7 inches of material printed already.
Right.
On Dailey. And when I was doing the notes, I mean, these notes were 70 and that was paring down, a lot. I mean, and I ended up skipping a lot that I did.
And I'm sure I can research that too. I mean, I'm sure even a Google search will give me more information as far as what their position is other than the death penalty and being against it.
What amici usually do is they argue in support of a party. What they have to do is they have to argue something not addressed by the party. I haven't read the rules, but like they take an aspect like if you read the amici submitted in support of Rodney Reed at the U.S. Supreme Court by the judges and the former prosecutors saying, well, there's DNA, we should always test it. Or, that the DNA could exonerate him. So and I've done on Rodney Reed, I've done comparisons of, if you look at just what their arguments are, you can see they're taking something that he may not have room to argue in his brief. So they'll argue something that he doesn't have time or room to argue about. That's an interesting thing to go over, like the nuts and bolts when you're doing this. And sometimes it will be one aspect, the strongest aspect of the argument, the amici will re-argue that.
Right.
But it depends on it. It's a case by case basis. I'll look and see what the Florida Council have argued.
And I've I was just Googling myself, and I'm actually like on the page and stuff, and it looks like what they're basically just are arguing is the morality of the death penalty, and they don't seem to be taking a position that he is innocent, more so as in that he could be, but they're not taking a strong position.
Correct.
Right. So that answers the question. Okay.
Yeah. If you go on the U.S. Supreme Court website, you'll see that there's a United States Conference and Georgia Catholic Conference. They've argued in capital cases or submitted amicus briefs in capital cases. Let's see.
Yeah. And it seems
former federal judges. Okay, Conference of Catholic Bishops in Stinsky versus Emmons, which is a case out of Georgia. Yeah, and they argue where life is at stake is more critical to justice that juries have liberal access to complete evidence. The irreversibility of the death penalty creates a moral imperative to give juries every opportunity to hear full truth. Applying two layers of deference in this case is imprudent. So it's going to be on a case-by-case basis to a degree, but here's one where allegedly new evidence that has been procedurally barred, they feel like a jury should have heard it. So they're arguing the jury should, even though it wasn't presented to the jury because, he knew it, but he decided not to present it.
Now, this is interesting. Yeah, the amicus briefs, this is what, there's a few paragraphs on this. It says the reviews of the facts of Mr. Dailey's case and concludes that the evidence of his actual innocence is persuasive. So they don't outright say he's innocent. They just, but it's persuasive, but that he was not able to present it at a new trial for procedural reasons. The brief declares that there is no legal or procedural reasons that could morally justify the execution. But now they say this of an innocent person. So like, it's lukewarm.
Right.
It seems like they're kind of nudging towards the innocence part. So it's not just in their perspective, just the morality of the death penalty, but from what I'm seeing here, that they believe that his innocence might be, well, there's a persuasive argument, which I disagree with, but at least now I'm getting
No, the courts have not found any of his arguments to have been persuasive.
No, not at all. But they do. I mean, I disagree with them, but yeah, but where it matters in the court, no, it absolutely is not persuasive at all.
They have most certainly found not persuasive at all. Yeah. And that's something too, but that's another flaw with the system, I think, is that more often than not, each successive claim is just an attempt to relitigate an already rejected claim.
Yeah, I've told you that since day one. Like, I'm amazed the appeals process is just literally people just filing brief after brief, wanting to relitigate the original trial versus, it's always, okay, yeah, ineffective counsel, like the same 5 things. But yeah, they just want to literally think that the appeals process is just to relitigate it.
And I heard this in one of, and I don't want to butcher it, but in one of Pat Brown's one of her live streams, she talked about even there are cases where you have special prosecutors that come in, they'll look at a case and they'll overturn it. Have you heard of something like this?
Yeah, well, I've heard, I've heard like that's kind of what who was it? Who was the guy in Los Angeles County who was just basically trounced in the re-election? And I can't remember his name. He was a George Soros prosecutor. And he's the one that's like, oh, well, the Menendez brothers should be released. So he started pushing for their release.
Oh, yeah, that's not George Gascon. That's the same.
Gascon, yeah.
Is Gascon the LA guy or the same? There's so many of these.
I think he's the LA guy, yeah.
Prosecutors, I can't keep them all straight.
And yeah, I mean, there are a bunch of, quote, conviction integrity units that have come in and have said, oh, well, there wasn't enough evidence.
Yeah, integrity
and so,
units, yes.
and kind of like what Marilyn Mosby did with Adnan Syed, to come in and say, oh, well, there's not enough evidence, or we think this was a Brady violation, so.
And why I don't like to relitigate unless there is real substantial evidence of innocence. I don't like this idea of them coming in and overturning something that 12 jurors have.
Yeah.
But they heard the evidence and it's guilty. And then you have appeals. It's like it kind of. I'm sure there's a step I'm missing here, or there's other legal factors that I'm just not understanding. But it's like that takes away the whole appeal process and everything else by just having this prosecutor come in and say, I'm going to overturn this.
Right. And well, the prosecutor can't really overturn it. But what ends up happening is that the prosecutor's office abandons the victims and their family, and they advocate for the criminal, and they go into court, and then they're advocating for the criminal, and the criminal's advocates are advocating for the criminal, and sometimes they have a fixed thing like Syed, where the judge is going to advocate for the criminal and find exactly what Marilyn Mosby tells her to find. And, everything's ready for a press conference. But sometimes you'll get that happening where the judge is like, hold on a minute. Okay. Like the U.S. Supreme Court with the Glossop case.
Mm-hmm.
They had the Oklahoma Attorney General advocating for Glossop, and they had Glossop's attorneys advocating for Glossop. So the Supreme Court said, hang on a second. And they appointed somebody to come in and defend the original opinion or the original conviction.
Okay, so at least that part's good. They'll have someone else.
And some courts will do that, but some courts don't. And we have the thing with the Menendez brothers, where if Gascon had been reelected, they would have been out probably by Thanksgiving or at least by Christmas, because he wanted to reduce their sentences. Now, he didn't want to declare them innocent, but he wanted to claim that their allegations of abuse were, true and mitigated their crimes, mitigated their sentences.
Yeah, that's crazy.
So, all right. Well, any final thoughts on James Dailey?
Based off the information that we've went through, both by looking at this two-parter, plus also looking outside of it, I believe he's guilty. I believe he's clearly convinced. It's clear and convincing to me that he's guilty.
Mm-hmm.
And as far as, Piercy, could he have been more involved in what happened? I don't know, but he was there. He was an accessory. He didn't do anything until, he had to, confess to his role in it. And but, I mean, it's kind of like, again, I hate to always refer to the West Memphis 3 thing, but as far as, how far Jesse got into what he got into, other than what we know.
Yeah.
It's like, well, I just, I was beating up on the boys and I brought Michael Moore back and I didn't anticipate this to happen. It's like, is that part the truth? Or, were they all in accord and said, we're going to kill these kids? But at the end of the day, it doesn't matter. You were there. You were a part of it. And
the boys are dead.
Right. I mean, it's done. And you contributed to it regardless at that point, the level. And that's how I look at it with Piercy in this case with Dailey. Dailey is the aggressor. He's the leader, as far as what happened, because he's the active one who did what he did, the stabbing, the drowning and choking. And that's what I get from that.
Yeah. Me too. So, and I think that this is like, as either the state said or one of the courts said, this is probably just an extension of their trying to game the system in 1985, 1986. They thought that they could, Piercy thought he would get a new trial, and Dailey thought he could beat the charges, and then he could go to Piercy's new trial and testify that he killed her and get Piercy off. That was the original plan. That plan did not work. Thankfully, the people they were using to pass the notes had the foresight to copy the notes so that the notes could be turned over and used. And you notice at 2020 special did not mention the notes at all.
That doesn't surprise me.
Nor did it mention the letters that Piercy wrote to Stacy Boggio. And there was another letter that I read, but I could not find it when I was looking. And so I ended up abandoning my search because it was taking too long. But there's another letter out there at another time that is equally damning for Dailey. So Anyway, but yeah, like I said, I don't know. The Attorney General, the process in Florida is the Attorney General requests that the governor set a date, and then the governor coordinates with the Department of Corrections to get a date and time set. And that hasn't happened. It's the same Attorney General, so I kind of don't understand why. Maybe it's on her list of things to do, and somebody in her office just hasn't had a chance to do it.
Right. And I
Um,
and I hope for Shelley's family, her remaining family's sake, I hope that they get to see the execution, not so much for closure, but for resolution.
yeah.
Because, I don't know if losing anyone you ever get closure. Um, it's just a resolution to finally end this so that it doesn't have to be a constant reminder in their life. And of course, this has been going on for decades now.
Hmm.
It's ridiculous.
Correct. Yeah. Yeah. Her sisters, Callie and Brittany. And then, I mean, she's got nieces and nephews as well. Yeah, hopefully they will all get a resolution, hopefully
Yeah.
this year, early next.
Yeah. And it's not, because like I want to see somebody die, like in a, hungering sort of way. It's just, but I
It,
believe in justice, and I do believe this is a part of it. Is you
right.
you you kill someone in such a horrific manner, you at this point you forfeit your life
Right.
for
And
that.
I think it's important that this process end. And the only end is if Dailey promised never to file another challenge
Right.
and to quietly do the rest of his life,
Hmm.
I could maybe say, okay, let's let him slide. But he's not. And he's probably got, quote, new evidence that they're just waiting for a new date. And then they're going to file a fourth successive motion to vacate after death sentence or a death warrant because again they want to just keep relitigating, and it's going to
Right.
be somebody else with bad, you know a first grade teacher that says Skalnick was bad seed from the day he was born,
Mhm.
or another confession from Piercy. Maybe since Piercy won't actually testify, they'll have a cellmate who will say, yeah, Piercy told me Dailey's innocent. I'm surprised they haven't tried that already instead of trying to get Piercy to testify.
Yeah, and then that's really the key is just to to stop re-traumatizing the families.
Yeah.
It's what happened was bad enough. And I would agree with you if there just be that agreement, he would accept the terms, and you know if they don't, execute him, so be it. And
Yeah.
it's not that. And it was a conversation I had before with a West Memphis 3 pro supporter, is whether I'm pro death penalty or anti death penalty. And I'm like, I'm really neither. Like, if there was no death penalty, I wouldn't scream. If it's there, it's
Mhm.
there. I just want them to not be in society anymore, to where they have the
Right.
potential to harm someone else. That's ultimately where I stand. Personally, it's like, if they're, I hate to, this part, I do want them to suffer to some degree, um, because of what they've done.
Mhm.
You know,
I feel
personally,
like prison's a lot worse than death, though. That's the thing. I kind of feel like
it depends,
life in prison could be worse than the death penalty in a lot of cases.
It
and I
depends.
guess,
It
yeah, like Charles Manson, he loved it.
Yeah.
And then you have others, they'll commit suicide because they can't handle it. I guess it does. It's perspective. If you're a lifelong criminal, or if you're someone who, let's say, never been in the system,
And
and you're in it, that might be worse.
I think part of the problem too is that a lot of times, as with Rodney Reed, Dailey, West Memphis 3, we see the media so often singing the song or the tune that they're given by the advocates for the people in prison. So whether they stay in prison or they're not in prison, their stories being told in the media, and I think that's what also hurts families more. So if they would
Right.
go into prison and shut the fuck up, then but the media won't do that.
because
They want to tell the story of the wrongly convicted.
well, yeah, and then also like, again, to lose the loved one is the most harmful thing, but then to see the convicted, treated like they're the victims,
Yeah.
and to see that the people that I mean, they killed your family, or they killed your family member, or what have you, and they're treated like, like royalty to the
Mhm.
to the outside world through like the media and things like that. I mean, that again, that's just re-traumatizing. That's all that it does, and
Exactly.
it's not fair. It's like the first thing was bad enough; it shouldn't have happened. Just but to keep doing that, and then my God, like I feel horrible for like the families of Ron Goldman and Anna Nicole, and you know I feel bad for the grandparents and the other family of Kaylee Anthony, and then of
Mhm.
course the West Memphis Three. They serve time, but then they get out. Like, man, what a nightmare! I can't even. You know, we know that it happens, but it's different when it's happened to you and it's
Yeah.
real, raw, and personal. I can't imagine the pain and the anger that they go through.
Yeah. That too. And seeing them made a victim by the media or portrayed as victims by the media is also, and like
Yeah,
I
that's the
wanted to go
worst
through
part.
I wanted to go through the TV and choke the life out of Dailey when he said, "Well, I can't help if the prosecution's been lying to them for all these years."
Right? Even to boot, to even say you're one of the family members who may be responsible.
Mhm.
Like in the Casey Anthony case.
Mhm.
Oh, the grandfather,
Yeah.
he may be responsible, or of course, Terry Hobbs, the stepfather, then of course John Mark Byers, and I mean, I even see people stupid enough to try to accuse Todd Moore, and he wasn't even there.
Right.
He wasn't in
Right.
the area. Just
Yeah, I'll never understand the weird like fangirl obsession with these killers that they just worship them.
Mhm.
It's freaky.
it is.
All right. Well, thank you for joining me today.
I was delighted to be a part of this. Thank you.
Thank you. And Kyle, thank you for soldiering on under
Yeah,
the weather.
absolutely.
I do
I'm
appreciate.
sorry I've coughed more than I'd hoped, but Happy New Year, everybody. Thank
Happy
you
New
for
Year.
listening.
Happy New Year.
Thank you,
Great to
guys.
talk to you, Rick. Have a wonderful year.
Likewise, Kyle. Thank
Really
you.
enjoy your show.
Thank you. Stay tuned.
Absolutely. Bye, Lisa. Take care.
Bye. Thanks. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans, and our guest co host, Rick Mullinax. If you like the show and want to know more, you can find us on Facebook or follow me on X at O'Brien L. Ann. In December 2024, Rob Chadwick, a former journalist with a lifelong interest in the truth of true crime and fairness for victims, passed away. Since his retirement, Rob has researched and written about a number of cases, including the murders of Steve Branch, Chris Byers, and Michael Moore in West Memphis, Arkansas, and the murder of Haymon Lee in Baltimore. We hope you'll join us in 2 weeks for a tribute to Rob from some of the members of the true crime community who knew him. Until then, have a great 2 weeks, stay safe, and hold your loved ones close while you can, because tomorrow isn't promised to anyone.